May I have your lordship's kind leave to mention item number 186 in monthly list, my lord. This is section 34. My money has been paid, but I am unable to proceed with my claim for interest, which learned arbitrator has held that I have to go to MSME council. I was praying if it could be given some precedence, my
34 not right now, sir. Sorry.
Spring from my lord's leave, my lord, to mention a matter, my lord, your lordship disposed of a section 11 and 14 application, my lord, of L&T item 6. It was item 6 on court on Friday, my lord. With regard to, my lord, there were 4 ODR platforms, my lord, where arbitrator was to be appointed. Lord, I believe, my lord, your lordship has recorded our consent, my lord, in the order, my lord. That is where, my lord, we are facing some difficulty with the clients. Lord, I think the order, my lord, records that, my lord, we have consented to the appointment of an arbitrator.
That's right. It can only be done with a consent, Mr. Sinha.
So, my lord, what
I'm not sitting in 11.6 that I can appoint an arbitrator. You know it very well. It has to be consented.
Yes, I understand.
Where's the question of not having the consent?
My lord,
And I have not appointed without the consent. Please don't make any submissions which are not correct.
No, Lord, I'm not. I'm saying, but we are facing some difficulty with the client.
You're facing difficulty. That's your problem.
Lord.
Before you come to the court.
Very well. Very well.
I'm not sitting in 11.6, Mr. Sinha. You know it very well.
Yes.
Can't appoint anybody without your consent.
Your lordship can terminate, but for appointment we'll have to go to the other. Your lordship can terminate, but I'll have to go to the other.
May I be permitted to mention item number 210? This is a matter coming from 1999. The dispute arose. What has happened is we've sold an hotel and now we are being asked to pay by the award, which is under challenge in section 34. We've also put in the money. Lordship, today all the petitioners are above 65 years old. Lordship will give some precedence.
34.
Yes, my lord.
34 not right.
Lordship,
I'm already hearing a lot of 34s. No precedence can be given at this stage.
Lordship, any day, it's a very short matter. 10 minutes is all that it takes.
No, sir, I have a lot of 34s right now with me.
Lordship, leave to mention that execution case number 470 2018. I was praying for inclusion under heading new chamber application.
Execution.
May I have my lord's kind leave to mention a matter your lordship had passed an order on 15th January. My lord had disposed of my execution application, but there is some correction in the order. In view of a terms of settlement, your lordship had disposed of the execution application. My lord, there is some correction in the order because the address is given wrong.
Address is wrong.
Address is wrong.
Just write the correct address to be mentioned tomorrow. Give the correct address.
I'm grateful.
I have your lordship's kind leave to mention a matter, my lord. This is a section 34, not in your lordship's
Gupta,
not in your lordship's list.
Not in my list. What do you mean not in my list?
It's not there in the list, my lord.
Then why are you mentioning it?
If it could be because all the
Mr. Gupta, not right now. 34, I am already hearing a lot of 34s.
At least it can be in the list, my lord, once. Then I'll
not right now. Let me finish those matters which I already are running on the board. I have a couple of matters which are running on the board. Let me finish it. I'll try to take it up. Very.
May we permitted to mention, my lord, a section 9 application, my lord, for inclusion, my lord, on fourth, my lord, the urgency is that, my lord, I am, my lord, a franchisee holder of a renowned, my lord, restaurant, my lord. I have with the power to, my lord, sub-franchise. That has been terminated, my lord, but still they are, my lord, operating that restaurant, my lord. And
when was it terminated?
It was terminated with effect, it will give an effect on 31st of January, but still, my lord, they are doing it and they have threatened in the Instagram and, my lord, the Facebook that they will continue to use my proprietary rights over, my lord.
You have already filed it?
My lord, I have already filed it. Let it appear on court, my lord. I am being led by Mr. Khanna, my lord, from Delhi, my lord. He will be coming on court. Yeah.
Section 9 application, my lord, it was filed during the emergency when this regular bench was not available on 22nd of January, and this matter was taken up by the coordinate bench. Their liberty was given to move the regular bench. I'm paying for inclusion, my lord.
Which 34?
Section 9.
Show me what is
new section 9, my lord. A registered development agreement was cancelled by a notice, publication in the newspaper. Thereafter, we have filed a section 9 application. Liberty was given to approach the regular. I'm paying for inclusion now. Any day, your lordship.
No, you have already mentioned it. I have refused it once.
So may I have your leave to mention?
It has been mentioned. I don't know who mentioned it. Somebody had mentioned it.
So may I have your leave to mention one matter?
My memory is not that bad.
I didn't.
Somebody mentioned.
I have your leave to mention a matter for a small rectification, Your Lordship. Lordship, we are
Rectification. Just make the rectification.
Lordship.
Just
Wait,
correction in the order.
the order. Just one name. We were led by Mrs. Manju Bhuteria, the learned senior advocate. The name is just
To be mentioned about.
And may I have your lordship's kind leave to mention an execution application, my lord. Lord, there is an outstanding dues of 85 lakhs to payable to the award holder. Lord, what we have come to learn that the judgment debtor, my lord, is property which was mortgaged with Kotak Mahindra Bank. They are auctioning it off, my lord. The auction was held, my lord, on 30th. My lord, all we are praying, my lord, we have filed an application, my lord. All we are praying that any excess amount recovered by Kotak Mahindra Bank, apropos their dues, my lord, to that extent, my lord, the realization be allowed. My lord, I've already filed a GA, my lord, in connection with EC 38 of 2024. My lord, any day, if your lordship permits, if the execution matter can be taken up for hearing, my lord.
Execution, not right now. Whatever it is, we'll see that.
My lord, on the date, my lord, whenever your lordships is taken up execution matter, if my lord, some precedent this matter can attend. If the property is sold off, my lord, the excess amount, my lord, will not be able to recover it, my lord.
Why can't you recover it?
But we do not know, my lord, what the award holder will do, my lord. The award debtor will do, my lord. They might, my lord, siphon away with the excess money, if at all realized, my lord, which will be paid to them. Apropos this sale, my lord, we do not know if that amount will be kept secured. But only to that extent, my lord. If any amount is
Whenever the execution, you can get it from some other source. It's not that it's only one property. Yes.
With your lordship, we have it permitted to mention section 34 matter for individual member. But for the 5-year-old petition order type.
We'll hear it. I'm already hearing a lot of 34.
Inclusion I'm praying.
Why is it not in the list?
I'm praying for it. It is a 2021 matter. It was running for some time, but thereafter,
Award is of which year?
about 2021.
Not right now.
With the
Wait,
lordship,
wait for some time.
with the lordship's leave, my lord, if I may mention a matter, my lord, this matter is running at serial number 154, my lord, of the monthly list, my lord. This is a section 34 application. My lord, the award was passed on 1st of July 2015, my lord. If my lord, at
I can't give you any precedence. Right now.
2015, my lord.
I will try to do it, but not right now.
Lordship, may I be permitted to mention 3
We
execution
have awards of 99 also. Awards of 2001.
My lord, I had mentioned the matter last week, my lord. Your lordship had
I
been
will,
pleased to
I will.
accept the mention.
I'll try
Great.
to.
Great.
The old matters, I'll try to finish it. I have already have a lot of 34s which I am listening to. Let me finish those. There's
Great.
no point.
Lordship, may I be permitted to mention 3 execution matters? Lordship, in this matter, by an order dated 2nd April 2025, the award debtors were directed to file their affidavit of assets. Then on 12th August 2025, warrant of arrest was issued against judgment debtor number 1, and he was produced before your Lordship on 9th of September 2025. Thereon, the matter was made returnable in the monthly list of November. It didn't appear in the monthly list of November. I had mentioned it before your Lordship in the monthly list of December. Lordship had allowed the mentioning. It didn't appear in the monthly list of December and January as well. So I'm playing for inclusion in the list.
With your lordship's leave, if I may permitted to mention the section 34. Your lordship, we are the award holder. Your lordship, the only urgency which we, the award holders, are facing is the company is undergoing liquidation. The award of 156 some CR is in our favor, your lordship. Your lordship, the liquidation is a time-bound process, and we are suffering a lot of losses because of that.
Not right now.
Your lordship, if it can be,
Not right.
your lordship, it's a liquidation process, or else I would not have mentioned, your lordship.
Not right.
It's a 2019.
Award of 2019.
Yes, your lordship, but your lordship, it is a, your lordship, the situation is that my 34 is of 2019.
That's right.
And it is a liquidation which has been going on. Your lordship, the liquidation, it is being suffered a lot, your lordship. It is only the liquidation, that is why I'm aggrieved here and I'm mentioning before this.
Wait for some time.
Your Lordship, may kindly permit me to mention a section 34 application, Lordship.
Wait for some time.
Your Lordship, this is a non-commercial matter and a dispute between two brothers in respect of a family settlement with an MOU, Your Lordship. Your Lordship, if the shares, this dispute involves only the some listed shares of some listed shares, Your Lordship. If those shares are sold out, Your Lordship, this section 34 will become in practice. Your Lordship,
whatever it is, wait for some time.
Statement of monthly list, item number 1.
Lordship, I am appearing for the petitioner on the last occasion, that is Wednesday. It was called on and none appeared on behalf of the respondent. Lordship, affidavit of service.
Affidavit of service taken on record.
Just
give the dates. When was the arbitrator appointed?
Lordship.
When was the arbitrator appointed?
Lordship, it was on 15th March 2023.
Pleadings completed on
Pleadings completed, Lordship, 21st May 2024.
21st May,
2024, Lordship.
first extension.
Extension, Lordship, up to 21st November 2025.
Any other extension?
No, Lordship.
Take down. The petitioner has preferred the present application under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for conclusion of the proceedings and publication of the award. Full stop. Learned counsel appearing for the petitioner submits that this court-wide order dated 15th March 2023 appointed a learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 21/5/2024. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months up to 21/11/2025. Full stop. Pleadings completed. What is it listed for?
Lordship.
What is the matter listed for before the arbitrator?
Lordship, cross-examination of PW1 has been over, and subsequently we have filed one amendment petition, and that is why recalling application yet to be filed.
And what is this AP which you have mentioned in the petition?
Lordship, reason, Lordship, kindly Lordship come to the page number 20, Annexure D, Lordship.
Yes.
Today was date fixed for hearing of the matter. However, I have received an email yesterday being the 10th September 2025 from the advocate on record of the respondent. Sir, Lordship, various occasions respondents sought for adjournment, and accordingly matter has been delayed.
Yes. No, I'm saying AP 195, which you have
AP
mentioned.
195, Lordship, that has been withdrawn. They have raised one point that the commercial and non-commercial matter, and accordingly we have withdrawn that application, and Lordship granted liberty to file application. Accordingly, this application, Lordship, has been filed.
Initially, it is further submitted that the petitioner had initially filed AP 195 of 2025 on the non-commercial side inadvertently, which, by an order dated 17/12/2025 was permitted to be withdrawn with liberty to file a fresh petition in accordance with law. Full stop. Learned counsel for the petitioners states, since the mandate of the arbitral tribunal expired on 21/11/2025, the petitioner seeks an extension of the mandate for a further period of how much time?
Lordship, 1 year, if possible.
8 months.
Lordship.
To enable conclusion of the proceedings and to enable the arbitral tribunal to conclude the proceedings and publish the award. Full stop. How many hearings have been held?
Approximately a year ago. Last minute of meeting.
Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct.
24th sitting, Lordship, done. 24th sitting.
The tribunal has already conducted 24 hearings. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 8 months from today. Full stop. With the aforesaid direction, the present petition stands disposed of.
Amitably. Appearance.
Lord, I appear for the petitioner, my lord. We're seeking an extension of time to complete the arbitral proceedings, my lord. The arbitrator, my lord, was initially appointed by an order dated 17th October 2023 of this honorable court. But thereafter, my lord, an application under section 15 of the act had to be filed, by which a substituted arbitrator was appointed.
Was appointed on 17th.
17th October 2023, my lord.
Then substitution.
Substitution was made on, my lord. The order was dated 9th July 2024. My lord, thereafter, on 15th July 2025, and by consent of the parties, an extension of 6 months was made, which, my lord, we have submitted has expired on 16 January 2026. Now, this application, my lord, has been filed for extension of time to complete the proceedings.
First paragraph, same hoga. The learned counsel for the petitioner submits that this court, by order dated 17/10/2023, had appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. Subsequently, an application under section 15 of the Arbitration and Conciliation Act was filed by the petitioner.
Yes,
was filed by the petitioner, wherein this court, by order dated 9/7/2024, appointed a learned arbitrator, substituted the arbitrator. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was further extended for a period of 6 months till 16/1, right?
On 16 January 2026.
Till 16/1/2026. Full stop. How many sittings?
My lord, 20 sittings till date.
22 sittings by the learned counsel for the parties, and the arbitral tribunal has already conducted 20 sittings and has disposed of various applications filed by the parties under section 17 of the act. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 6 months.
Maybe more than that, my lord. A little bit
Why?
of time is required, my lord. It's a partnership dispute. The valuation is under challenge, my lord.
The valuation report has been filed, which has been challenged by the respondent.
There are several section 17 applications which are also pending, my lord.
You're asking for 6 months, for a period of 6 months from today. Full stop. With the aforesaid direction, the present petition stands disposed of. You have only asked for 6 months.
Grateful, man.
Deeply obliged.
But 3 and 4 are, my lord, where, my lord, adjourned on the context that, my lord, that Supreme Court matter was pending. But now, my lord, that's been decided. 2-1E court, my lord, would be the 29A court. So, my lord, as far as 3 is concerned and 4, well, this is the judgment, of course, my lord. The
judgment I've seen.
Yes. So 2-1E court is this court only. So Lordship has got the jurisdiction to extend it, my lord.
The fundamental opposition on our end is that this is not the 2-1E court. The Lordship would see the previous order that records this submission.
That's right. That's what they were saying, that this is not the 2-1E court.
So let us, my lord, then argue it out here before, my lord. 3 is my junior is there, so he will argue it. 4, Mr. Or, my lord, 4 I can argue it's similar. He's saying that, my lord, it's the same. My lord, kindly takes, my lord, the application, my lord, and the agreement.
Let us see the order also, the judgment. I have not really gone through it completely.
But paragraph 21
Paragraph
onwards,
21 onwards, my lord, is, I think, paragraphs 21 to 27, my lord.
এইটা শিলা ছলগুলো স্যার আপনি কোনটা করছেন
কোটটা করছি
কোটটা বের করেন
Your Lordship takes, my Lord, 21. Interpretation of the expression quote in 21E. Lordship, that's at page 21 of 27, my Lord, paragraph 21. It is a settled principle of statutory interpretation that a defined term must ordinarily bear the meaning assigned to it unless the context otherwise requires. Further, in the state of West Bengal versus Associated Contract, a three-judge bench held that no court other than the one defined in section 21E gets qualified as court under part 1 of the act. Then, my lord, the observation is there. Similarly, in Nimate Resources Inc. and another versus SR Steel, where this court considered 21E in the context of section 14 observed as under. Then, my lord, the finding of that judgment is there. Then kindly comes to, my lord, 23. Nimate Resources clarifies two proposition of enduring relevance. First, that applications concerning conduct, continuation, termination, or substitution of an arbitral mandate, whether under section 14 or otherwise, are matters of curial supervision and must be instituted before the court as statutorily defined. Second, that the jurisdiction exercised under section 11 is limited and exhausted upon the constitution of the arbitral tribunal, leading to the appointing court becoming functus officio thereafter. These principles apply with equal force to section 29A. The extension of mandate or substitution of an arbitrator under section 29A does not partake the character of appointment under section 11. But this is the distinction drawn, but is a measure designed to ensure timely conclusion of arbitration. Absence of any contextual indicia to the contrary, the expression court in section 29A must therefore be accorded the meaning assigned to it under section 21E. Then, my lord, chief engineer is recorded, and ultimately lordship sees, my lord, section paragraph 25 deals with, my lord, section 42 of the act. Then, my lord, kindly comes to 26. It may be argued that since application under section 11.6 for the appointment is filed before High Court, all successive applications, including 129A4, must be made to such High Court. We need not labor on this issue as a constitution bench of this court in the state of Jharkhand, affirming the decision in associated contracts, has held that solely because a superior court appoints an arbitrator or issues directions or has retained some control over the arbitrator, it cannot be regarded as a court of the first instance for the purpose of 42. I think, my lord, here, with greatest of respect, they should have added, my lord, that under section 11, it's a supervisory jurisdiction, my lord. It's not, my lord, an jurisdiction for, my lord, adjudicating disputes. That's not recorded, my lord, here, but should have been. Then, my lord, kindly sees 27, the conclusion. In view of we allow the appeal, set aside the reference of the division bench and the subsequent judgment of the single judge and restore the judgment of the commercial court. Parties are, my lord, then 29. So, my lord, it's the 21E court which has been given the jurisdiction, since it is the court which can adjudicate the disputes between the parties. Now, my lord,
So this court becomes functus officio after the appointment.
yes, my lord, because, my lord, I think, my lord, this did not require much of a, my lord, consideration, because section 11 is a supervisory jurisdiction, my lord, which the High Court has over the state. So, my lord, appointing an arbitrator cannot, my lord, give jurisdiction to a court for adjudicating the disputes, my lord. That would be the only court under section 21E, my lord. So, if that be so, my lord, 29A would always go to a court, my lord, where, my lord, the disputes can be adjudicated, not the supervisory jurisdiction, my lord, where, my lord, it can be, my lord, that parties have appointed by, lord, by, my lord, consent. Then, my lord, there is no section 11. Then, my lord, where will they go, my lord? It can't be the court where section 11 can be filed. So that, my lord, I think one line would have saved, my lord. Again, with that, somebody would go up to the Supreme Court again. Few months would be lost. But I think, my lord, that should have been clarified. Now, my lord, kindly sees our matter, my lord, item number 4, if your lordship kindly takes, that's AP 735. Oh. My lord, this pertains to, my lord, no, supplementary thing. This, my lord, pertains to an agreement whereby, my lord, parties have executed for certain financial services. Now, my lord, if your lordship takes the supplementary affidavit, I'm told, my lord, the agreement is enclosed to the same. My lord, kindly comes. My lord, kindly sees, my lord, the facility agreement in the supplementary affidavit starts from page 12. Now, lordship will find this is a facility agreement where, my lord, the agreement is made at Delhi on, my lord, second day of date 2019 between the, my lord, petitioner and the respondent. Now, my lord, kindly comes to May. My lord, kindly comes to, my lord, the clause which the parties have agreed to. Page 16, my lord, if your lordship kindly comes, my lord. My lord, 13 is the governing law, jurisdiction and arbitration. So it's well defined in the agreement. 13.1, if your lordship sees, my lord, this agreement shall be construed in accordance with the laws of India and subject to the arbitration clause below, shall be subject to the exclusive jurisdiction of the competent courts in Kolkata. So therefore, parties by agreement has agreed that, my lord, it would be the courts at Kolkata. Exclusive word is no longer required, my lord, in view of the judgments which have been passed earlier by the Supreme Court. No longer, my lord, we have to put any emphasis on the word exclusive. So, my lord, competent courts at Kolkata. So therefore, my lord, this would be the court, which is, my lord, the court which would adjudicate the disputes between the parties, because, my lord, in the district of Kolkata, lordship is the 2-1E court. There is no other court which is 2-1E, my lord, under the district of Kolkata, my lord. Because this is the court which is the principal civil court, my lord, as defined under the Arbitration Act. If your lordship kindly takes once the Arbitration Act, my lord, section 2-1E.
Where do you get that from, Mr.? What kind of?
Kindly sees the language of 2-1E, my lord. Court means in case of an arbitration other than.
Just a minute, just.
Yes, sorry, my lord. I am extremely sorry.
Yes.
Court means in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction, which my lord is, in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of arbitration, if the same had been the subject matter of a suit. So, my lord, till here, lordship does not have any difficulty. This is the court.
Mr. Banerjee, court means principal civil court of original jurisdiction in a
Yes.
district. That
Yes.
can't be this court only.
No, in this district, lordship is why I'll read the later part that will clarify it. That is what, my lord, we make a mistake. But does not include any civil. This is very important. Kindly see, but does not include any civil court of a grade inferior to such principal civil court. So, my lord, if there is another civil court which is inferior to my court, my lord's court, then, my lord, it would not include that. So that's the distinction, my lord, of a grade inferior to such principal civil court or any court of small causes. And this, there is a judgment, my lord. I don't know they're carrying it or not in.
No, you better carry all the judgments because I just don't agree to this argument of yours.
But this is established, my lord. This is a.
You come up with all the judgment which establishes you as this only civil court.
Because lordship is the superior civil court, my lord. With
you come with all your judgments.
Very well, my lord. I'll show that. But that this proposition is well settled, my lord. I have no, my lord.
Come with all your settled arguments and your judgments to support this contention.
Very well.
There are at least 5 judgments to the contrary, and exactly what your lordship is.
I'm absolutely sure.
Yes.
My lord, I will show it to my lord, my lord. My lord keeps it tomorrow itself, my lord. If your lordship is against me, let me argue it out tomorrow itself, my lord. I'll show it, my lord. This is decided by the Bombay High Court, even I'll show it to my lord. This is decided.
I want decisions of this.
I'll show Supreme Court.
As you.
Yes, I'll show
As
Supreme
the
Court.
principal civil court
Yes,
in this
yes,
jurisdiction.
yes, my lord. I'll show Supreme Court, my lord, on this issue only. I'll show Supreme Court only.
Which declares Calcutta High Court.
My lord, which declares the High Court of that district, my lord, as the superior court having ordinary or original civil jurisdiction. I'll show that, my lord. But it would be in Bombay, it would be in Madras, it would be in Calcutta. I'll show that, my lord. The City Civil Court does not have jurisdiction, my lord. And the Commercial Courts Act of our court, my lord, and the rules of our court. I'll show it.
This will take time.
Any day, my lord, any day lordship fixes. Tomorrow itself, if you keeps it, or my lord, day after.
What is the urgency? No urgency.
The urgency is, my lord, the arbitration is stopped. Arbitrator is waiting for the order, my lord. The
arbitration
extension
has not been stopped because of this.
Obviously, 29A, my lord, he will not proceed, my lord. Application is fine. Because this question is also, my lord, there whether this court has got jurisdiction to extend. We are at the stage of final argument, my lord, in this matter.
So he must be concluding it.
No, he's not, my lord, because of this question. Had it been an ordinary 29A, they proceed.
My lord,
But
the
since a question of
arbitration
jurisdiction is concerned, sometimes the arbitrator is also.
That is, my lord, incorrect. My lord, may I just correct? My
Little
lord, the
difficult for
arbitrator has, my lord, decided not to proceed with the matter because, my lord, the arbitrator's staff's fees has not been cleared. There is a specific order to that effect. Both me and Mr. Banerjee are appearing in the matter.
Mr.
In the matter, my lord. In Mr. Banerjee's matter, this is the ground, but in the matter that my learned senior is arguing, that is the reason.
I must clarify this, my lord, because I am appearing in one matter, item number 4 exclusively. My lord, this is one of the issues, but the main issue, my lord, your lordship will appreciate that this is pending for almost a year. We are at the fag end. Now,
Doesn't matter whether
argument will finish in
whether 29A will be decided by this court or
absolutely. I appreciate, my lord, but arguments
Should
will
proceed.
commence.
Should
Arguments,
proceed, my lord.
arguments are already, my lord, at the stage of commencement.
make the
matter to
payment.
Mr.
Make the payment. He will.
No, that is with respect to one. That is with
We will
respect
hear
to
it.
additional payments. Schedule 4 payment already made by both the parties.
By both the parties.
Additional payments.
So, my lord, it cannot be a question of payment if Schedule 4 payments are made. It can't be.
That's a payment on request. That's another issue. The main issue, my lord, is that arguments will hardly take, my lord, 2 to 3 sittings. It's a plain simple for us, plain simple case for recovery of money lent and advanced. But here the arbitrator has requested that since this question is pending before the court, let it get over. So we have, my lord, bowed down to the expression of
Question of jurisdiction, my lord. Sometimes the honorable judges, retired judges also, my lord, feels as if, my lord, if it is other way around, then
All right. Day after tomorrow.
they have to. Grateful.
Not today.
Helpful. Grateful. Now, 5.
Lord, my application under 29A for extension of the mandate, my lord. There was a direction by your lordship to file an affidavit by the other side showing that
My lord, may I
the
just enter,
moratorium
my
would
lord, the-
continue.
Yes. The-
Moratorium is continuing.
Yes, my lord. The
No,
moratorium.
my lord, according to me, no.
My lord, there is a
See
short
the
point of
affidavit.
law, my lord, involved in this. I'll tell your lordship, my lord. My lord, the statute requires the moratorium, my lord, the CIRP to be completed within 180 days, subject to extensions, but not more than 330 days. That has now been interpreted by the Supreme Court to be directory and not mandatory. And my lord, it is clarified that even after 330 days, time can be extended. In the facts of our case, the tribunal had extended the time even beyond 330 days. My lord, ultimately, my lord, the CIRP, my lord, could not, my lord, reach any conclusion because none of the plans which my lord proposed for taking over of the company were approved by the creditors. So, my lord, in that event, my lord, I, the liquidator, filed an application requesting for the company to be sent to liquidation. That application, my lord, was heard on the 24th of September 2025. To my affidavit, my lord, I have annexed, my lord, if your lordship sees, my lord, page 4 of my affidavit, the first entry there, listing date, my lord, last 24th September 2025, and my lord, thereafter, your lordship will see order reserved. So the application whereby I'm saying that send the corporator to liquidation has been heard and reserved for orders. My lord, unfortunately, my lord, for whatever reason,
My
the
lord,
order,
this
my
is
lord,
the screenshot, but this is the actual order of that day.
No.
24 na order.
Can you show me?
No, only one copy.
You're representing. You have
This order is there. It shows nothing has been heard. And if Lordship sees the next thing, that
Further consideration.
no time for hearing
Huh.
and no next date is also given.
No, date has been given. The matter for further consideration on 24/9/2025.
my lord, that makes my case better.
Just
But
Sorry.
Yeah,
kindly,
we are in a wrong
kindly,
order.
kindly, this is the previous order. Kindly seize this order.
which, can you give me a copy?
Yes, give a copy. Give a copy to
My lord,
him.
just
Just give,
look out.
give that copy first, then I'll give this copy to him. Give a copy.
Nowhere shows that their application
Date has not been given, but that doesn't mean that only date. It's a
not even
mistake.
heard. He says order reserved.
Sir, due to paucity of time, this matter could not be taken up for hearing and list the matter for consideration on. They have forgotten to give a date, nothing else.
No, not only that. My lord, the screenshot shows matter heard and reserved.
Yes, my lord, may I just point out why?
Kindly see the,
If your
see the,
lordship
my
will-
lord.
This is the order of 24th of September.
Yes, my lord.
Right?
The affidavit, my lord.
The screenshot is of 24th of September, which is for further consideration, listing purpose for further consideration. Order reserved.
My lord, if your lordship will just see, my lord,
For orders.
I'll just clarify the
There's some
confusion.
anomaly, my lord.
No, my lord, I'll just clarify the confusion. If your lordship, my lord, sees the liquidation application is, my lord, IA 15 of 2025. That has been heard. The other application where Mr. Jishnu Chaudhary was, my lord, pressing for reliefs for his client to get, my lord, a share in the pie, that is IA 493 of 2025. That is pending. But the application for liquidation, my lord, has been heard and reserved for orders. So, my lord,
I do not know
whichever
what is
way.
his difficulty if the arbitration proceeds.
It cannot, my lord.
Can't proceed.
I'm an officer of the court. I have to be.
My lord, the moratorium has not been extended, subject to correction.
Moratorium, if the order has been reserved and it is pending, then the moratorium has
My
extended.
lord,
That is how
that order does not show it's pending. My lord.
we'll keep it
With-
after some
My lord, with just one sentence in the judgment,
I-
it'll.
It's a clear. I have no doubt about it.
This I was citing with some more conviction. Kindly consider, my lord, paragraph 25. Give me a copy.
Please give the citation.
Give me a copy of that. I'll give him both. Paragraph 20.
ফেরত দেয়নি পার করে নিলি দরকার হ্যাঁ reference. Do you have the reference?
25 of citation. I'll just.
Hmm.
2020 13 SCC 20.
2013.
Para 25.
25, my lord. The second half of the paragraph.
This is for the very good reason that when a moratorium is.
Yes. Yes.
Only thing is that, my lord, many orders have been passed subsequent to this. My lord, this cannot have a omnibus effect unless it is relied upon and extension is granted in terms of this order.
My lord,
My lord, there are so many orders, my lord, prevailing in each.
This will not solve any purpose. The arbitration.
I
proceedings
understand, my
will
lord.
Not solve any purpose.
My lord, here is a creditor,
says
my lord.
Until the liquidation
My
order
lord,
is
going
passed.
from post to pillar, my lord.
Until the liquidation
He will
order
get
is
nothing.
passed.
It is if the company is in moratorium, what does he get? Even if it goes post to pillar to
that-
pillar to post, it doesn't matter.
Section
respect,
14
my
is
lord,
an
that-
express bar.
There I
Section
was, my
14
lord,
is the bar.
really.
That I know.
My
This
lord, there I was really joining issue, my lord, with greatest of respect, my lord, that moratorium has not specifically been extended by the court.
For my friend,
all I can do is I can pass an order stating that the order has been reserved by the NCLT. We'll wait for the outcome of the order. If the moratorium has been extended, it has been extended.
My lord,
But I would rather say I should not record anything. We'll keep it after. When will it in likelihood the order will come?
last came up in 24th September. Thereafter, no dates.
my lord, with my lord respect, my lord, on the tribunal, my lord,
File an application. Do something.
Mention.
You can mention it.
You mention it.
I have already mentioned it. We are also.
Will your lordship, my lord, just record one line? It may, my lord, help us, my lord, before the bench.
Some observation, my lord, will help us, my lord.
Learned counsel for the respondent
13 SCC page.
has drawn the attention of this court to the fact that on 24/9/2025,
Page number.
the tribunal had reserved the order. Though he submits that till date, no order has been passed. Full stop. Since the matter is pending adjudication before the National Company Law Tribunal,
Thank you.
Calcutta bench, and the issue of moratorium, extension of the moratorium, is pending before the concerned tribunal, the present application is adjourned for a period of 4 weeks, expecting that the tribunal expecting that the order reserved by the tribunal would be placed by way of an affidavit before this court, before the next date.
Only one thing, my lord. 4 weeks will take us.
6 weeks.
My lord, by way
What
of,
will take us during the Holy Dol Jatra week, I think, presume. First week of March. Could it be the following week?
Following week. After 4 weeks, we'll keep it. The date we'll give is 10th of
my
March.
lord, only one indulgence. If it could, my lord, be tendered across the bar, my lord, the order, which is ultimately passed, because, my lord, the liquidator, my lord, has been operating from Bombay. So, my lord,
You can file an affidavit when the order comes.
find it.
You place the order on record by way of an affidavit.
Wait.
This is only to, maybe after this, you'll get the order also.
Wait.
Extremely grateful, man.
Great. Even when liquidation commences, leave of the tribunal is necessary to initiate a proceeding. But there's now ambiguity whether initiation would include an old
This
proceeding. or not.
supplementary affidavit I'm taking on record.
Yes, my lord, kindly do so.
Supplementary affidavit filed by the respondent is taken on record.
Grateful, my lord.
10th of March.
Grateful, my lord.
And the receiver in this matter, my lord.
Yes.
Try Amanna. No.
Lord, this is
You're the receiver.
Yes, application. Lordship, we were able to, as per my instructions, we were able to trace the asset. We were able to locate it. We kindly need give us more time to schedule the visit. My lord.
You have not been able to conduct the
No, my lord,
proceeding.
in compliance your lordship's direction, I sent them a letter for making visit, not making arrangement for my visit. My meeting was held with them, and coming week I will be going for visit, my lord.
All right, learned counsel for the petitioner seeks and is granted.
Ayo.
Further, how much time? 4 weeks. 4 weeks. Seeks an adjournment for 4 weeks. The same is granted. List after 6 weeks.
My lord. Grateful, my lord.
All the matters same.
Lordship, in item number 7, we have done the paper publication for public auction. We have received a few bids and we are yet to complete the process of sale.
Same order. Take your time, you do whatever you have to.
Lordship, in item number 8, the receiver was here. She went.
Your lordship,
Yes.
your lordship, I apologize, your lordship. The report is not. I have done everything, but your lordship, the report has not been done as of
Learned
now.
counsel for the receiver seeks and is granted. Receiver appointed by this court seeks and is granted further time of 2 weeks to file her report.
Your Lordship, just one indulgence. I have visited, but unfortunately, Your Lordship, the equipment is under the custody of the GST authority. Lordship, I have communicated the order. Like I visited the GST office. I showed them the order that Your Lordship has passed. They said they have already perused the order, but Your Lordship, the GST officer has told me verbally that a similar proceeding is going on in the Jalpaiguri circuit bench, and Your Lordship, I have already mailed them yesterday to provide the relevant papers and orders, but Your Lordship, they have not done anything as of now.
Which is that proceeding in Jalpaiguri circuit bench?
Even I was not aware of that.
Just try to find out. You file your report with whatever information you have.
Grateful, Your Lordship.
List after 6 weeks. And in the meantime, you please find out what is the proceeding which is there in the circuit bench.
I will do that, Lordship.
Miss Sen, whatever the report is, you file it, whatever it is.
Lordship, the GST officer has told me that if Your Lordship passes a direction to the GST authority, then they will.
First you file your report, then I'll file.
Yes,
Then I'll give a direction. But first try to get the information.
Lordship.
I'm going to receive one more.
Lordship, item number 9, the asset is not traceable. We tried to locate the asset, but we couldn't find it. I have been instructed to withdraw the matter.
Learned counsel for the item 9, right? Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn.
Lordship, similar order for item number 10, 11, and 12. We are unable to trace the asset.
10, 11, 12, same order. 9, 10, 11, 12. Do you have any instruction, written instruction, or you're the advocate on record?
Lordship, my senior is advocate on record.
Who's your senior?
Advocate Shubhankar Chakraborty.
Where is he?
He is out of town.
He is where?
He is in Delhi. He is on legs.
Not here. No instruction from the client.
We have received the instructions.
Where's the instruction?
Lordship, it's in the email.
Give the email. Give a copy of the email. Give it later.
I'll give the copy.
Okay, print out. उसमें लिखो. Learned counsel for the petitioner states that since the petitioner is unable to trace the assets, her client has asked her to withdraw the present petition. Full stop. The instruction from the client to withdraw the present petition is taken on record. Give it right now to the court. When will you give it?
I'll give it today. I don't have it right now with me.
Go to the office or get a printout, give it to the court. Okay? Is taken on record. The present petition is dismissed as withdrawn in terms of the instruction. Full stop. Or if you want, I can keep it tomorrow.
Right. That would be
Tomorrow? 9, 10. Tomorrow, not today. Tomorrow. Keep it tomorrow. 9 to 12. To be mentioned. To be mentioned tomorrow. Come with the instruction tomorrow. I'll record.
Grateful much.
Gopal. Next.
Well, in this matter, there is a interesting question of law which has evolved, my lord. This is my section 9 application. Is that, my lord, there is a section 7 which has been filed also before the NCLT. My lord, unlike, it's not admitted. Unlike section 95 to 100 of the, my lord, IBC, where filing, my lord, takes us to a moratorium. Mere filing, no admission is required. Section 7 is not like that. Unless there is a Section 7 admission, my lord, there is no application per se in the eye of law unless it is admitted. Now, my lord, the concept is that if there is a Section 7, then, my lord, it's a quantified claim. My learned friend's argument is quite high on that, should be. It's a quantified claim, then there is no dispute. And if it is not admitted, then, my lord, it is not a quantified claim. Then, my lord, it is usual that the dispute exists and I have a right under Section 9. So, my lord, if your lordship kindly keeps it next week, my lord, I have to file a reply to this point which he has filed. So I can file that, my lord, and come back, my lord. It's a pure question of law now, my lord. Then only I can have my
Counsel for the petitioner seeks and is granted further time of 2 weeks to file his reply to the affidavit in opposition. List on
May I
25th
Yes.
of February.
25th. Grateful.
My lord, there to serve us, my lord.
Yes, yes, I will serve. Yes, yes.
Right.
My lord, kindly, my lord, that also lordship records. I'll serve him a week before that, my lord.
Seeks and is
Definitely.
granted, so with advance copy to the.
Yes, yes.
Deeply appreciated.
Grateful, my lord. I'll do that.
And my lord, item 42.
Item 42, there is no Section 7. So
Yes,
that will proceed
absolutely.
independently.
42, my lord, my prayer there would be, I'm being led by Mr. Shubhoshaji Chaudhuri in that. I'm indicating to my learned senior friend, I'll be seeking time in that. When it's called, my lord, I'll be seeking some accommodation.
We'll see that.
If you, my learned friend wants it, wants that on 25th, we can have it on 25th.
That's
So
what
lordship
my
can,
prayer would be.
my lord, kindly passes that order in 42. I will not stand in.
Same connected?
They're connected entities of sorts.
two
One is a
agreements.
proprietorship concern. This is a company.
That's a
42, my lord,
proprietorship.
concern. But they're related, my lord, in a way.
Item 42, sir.
40, my lord.
40, 40,
Item
40.
40. Item 40.
Their pleadings are complete, my lord.
40. George have ordered.
Item 40.
40.
40.
Learned counsel for the your respondent. Learned counsel for the respondent seeks and is granted. States at the arguing counsel, Mr.
Mr. Shubhoshaji Chaudhuri, my lord.
Shubhoshaji
Chaudhuri.
Chaudhary. Is in some personal difficulty. He prays for an adjournment. Let this matter be adjourned. List on 25th.
There, this point is not there, my lord,
Yes,
but pleadings are
since,
complete.
since they're similar,
Yes, parties are same.
25th of
Grateful.
Your Lordship, I am appearing on behalf of the petitioner. Today is fixed for the filing report of the receiver. But Your Lordship, we have received the verbal instruction. The technical person being the specialized engineering firm has been contacted, and their presence is required to operate the along with the receiver from the report. So kindly taking the some times.
Who's the receiver?
Huh?
Receiver, where's the receiver's report? Who's the receiver? Did you serve the receiver?
No, sir, we have not served the.
Then you have taken time.
Yes, sir.
Why didn't you serve the receiver?
Because sir, the not a instruction from the client. That's why the.
I have given you order to serve the receiver.
Yes, sir.
Then
But sir, client not instructed. Is that's why the.
client instruct or the court orders, madam. What is
No, sir. The court orders were.
what's wrong with you?
Sorry, sir. I apologize, sir.
Who's your senior?
Arnab Sinha.
Where is he?
Says busy in another court.
Call him.
Okay, sir.
And you should know, you don't take instruction from the client, you take instruction from the court. You're officer of the court. This order. What is the last order which has been passed by this court?
1st December.
What is the order? Have you read the order? Why? Where's your file? Where's the last order? Why didn't you take a printout of the last order?
The copy was.
How long in the profession?
Yes, sir.
When did you pass out?
2022, sir.
Already 4 years. When you come to the court, at least you should know what is the last order which has been passed by the court. You have to comply by the order.
Yes. I apologize, sir.
Not today. Call your senior tomorrow.
Lordship, appearing on behalf of the respondent.
Lordship,
Lordship's direction, I'm filing my
Miss
affidavit in opposition.
teacher, as a younger member of the bar, she should know how to address.
Lordship, in this matter, there was a direction for exchange of affidavits that has been.
Lordship, I'm filing my affidavit.
The respondent has given the affidavit in opposition on 30th. Lordship will take 2 weeks' time to file our reply.
Lordship, I have already served them.
Yes, it has been served.
Affidavit in opposition filed by the respondent is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks' time to file reply to the same list on 24th February.
Grateful, Chair.
Grateful, Lordship.
Number 14, my lord, will it be taken?
First, you should teach your junior, instruct your junior what to speak, how to address the court. And second, you should also learn that when the matter has already been passed over, not even passed over for tomorrow, then you should not interfere in the judicial proceeding.
My lord, I attended my appeal. I was of the intention that it was.
If you will do that, she'll learn more
my
better
lord.
things from you.
My lord, I will be present tomorrow, my lord. I tender my apology on.
Lordship, this is my Section 9 application. Lordship, on the last occasion, I had taken time because they had proposed a settlement by which they wanted to pay the installments of November, December, January till the end of January 2026. Lordship, they have paid the installment for January 2026, but November and December is still pending. They have not paid. Lordship, my instruction is to proceed with the Section 9 application. Where is the chart?
If they're paying in January, they'll pay for the others also.
Lordship, November and December has been pending for a long time. They have only paid the current installment. The pending installments have not been paid. And by the 5th of February, another installment will be due. If Lordship directs 1 week or 2 weeks' time, I can again serve upon them, asking them to pay, and then we can come back.
Come after 2 weeks.
Lordship.
Learned counsel for the petitioner seeks further time of 2 weeks. Seeks an adjournment. Seeks and is granted 2 weeks time to explore the possibilities of an amicable settlement. List on 24th of February.
I will write the letter specifically.
Lordship, your lordship, before I will give this votes time, your lordship. Lordship, I am in quicksand today. Lordship, I'll tell you, by your lordship's order dated 5th of January, I was supposed to file my affidavit in opposition. Lordship, the key managerial person who is adept with the instructions in this matter is a septuagenarian. He was sick for a period of 1.5. Lordship, I'm simply praying for an extension of 2 weeks to file my opposition.
Sure.
Your lordship will do that. In any event, your lordship, opposition would be required.
What you're saying is correct.
Your lordship, I'm submitting on instructions, your lordship. Otherwise, your lordship, on the bare perusal of the section 9 application, your lordship will see this. They are praying for an injunction in the nature of an attachment before judgment. Settled principles of this honorable court in Sunil Kakrania, judgment of Justice Bhaskar Bhattacharya in Kohinoor Properties, Raman Tech, your lordship, bare pleadings without any material assertion that I am going to flee away. Section 9.
Lordship, then they can secure my amount.
No
That's
question of
it.
securing. No question. Securing is attachment before judgment. I'll
I won't attach their bank accounts if they secure the amount.
by way of an opposition, which is why an opposition is necessary. Otherwise,
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 4 weeks. 4 weeks. 4 weeks are date there.
date for you.
Just take a date.
I apologize.
4 weeks. Monthly list of month.
Date.
Lordship, in this matter also, there was a direction for the respondents to file their opposition, which has not been filed. Go ahead, appear.
Who's for the respondent?
Mr. Moinak Bishash appeared for the respondent. We have his report.
You can proceed.
Lordship, I'll proceed with the section 8. Lordship, this arises from a loan agreement dated 18 December 2023, where the loan amount granted was 20.26 lakhs, which had to be repaid in 36th installment. The first default was on 3rd March 2025. We recall the loan on 17 July 2025 with a claim of 13.05 lakhs. Lordship.
Loan agreement is page 19.
Yes, Lordship. The agreement is starting from page 18. Yes, 90. 90. Lordship, the arbitration clauses at clause 8, page 29.
Yes.
Lordship, there was an appointment of a receiver, but appointment of an arbitrator, but thereafter there was an opposition from them. So the arbitrator
Keep
has
it tomorrow.
Lordship, I'll give a notice to the
Give a notice. None appears for the respondent. Let this matter be listed tomorrow or day after? Day after?
Day after.
Day after.
Huh? Oh,
We'll attach it if they don't come.
My lord, this is my section 9 application, my lord. They have filed an opposition, my lord, taking a point of jurisdiction, my lord. This court doesn't have jurisdiction.
Yes.
My lord, if my lord pleases.
Where's the affidavit? Where's the affidavit? We had asked.
My lord, if my lord pleases, gives us 1 week time to file a reply. Otherwise, the agreement states that Calcutta is a court, my lord.
My lord, only 1 point, my lord. My lord, the loan was taken. The respondent company came to the house of the respondent number 2. The petitioner came to the house of the respondent number 2. The house is located at Delhi, my lord. The main headquarters is located at Mumbai, my lord. My lord, even the Sumedha hotel is located at Kailash Enclave at Delhi, my lord. My lord, they are stating, my lord, we all over came from Delhi to Kolkata to take up this loan, my lord. My lord, and sanction this loan and again went to Delhi, my lord. My lord, this point is totally baseless, my lord. My lord, this application should be totally rejected, my lord, on the ground of jurisdiction, my lord. It is out of jurisdiction, my lord. My lord, their headquarters is in Mumbai. And I live in, my lord, at Delhi, my lord. There is no office registered in Kolkata, my lord. In Calcutta High Court, there is no office, nothing. There is nothing, no trace of this company. I even never stayed here, my lord.
My lord, if I may come back with a reply, my lord, otherwise I can show it from the agreement that this court has jurisdiction, my lord.
Affidavit in opposition filed by the respondent is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the same list on 24th February.
Much obliged. Grateful.
Grateful, my lord.
This is my application under Section 9 of the 1996 Act, my lord. The petitioner, my lord, is a contractor under the railways who prepares not concrete sleepers. These sleepers are used not to bind the railway tracks. The concrete sleepers, which are not used for railway lines, tracks, these are prepared by him. There was an agreement that I shall prepare and supply the concrete sleepers, and they will lease out a land to us for the purpose of setting up the manufacturing unit. Now, they leased out the land in 1986, my lord. This is going on.
Page.
That agreement is at page 17, my lord.
Page 17.
Page 17. This is the 2007 renewal. There was a prior one also.
Mr. Banerjee, 29th March, right?
My lord.
29th March. What date? 2017.
2017. This 7, my lord. 2007.
2007.
7. Now, lordship will
Period of the agreement.
10 years is not 10 years with a option to renew. Your lordship will find that
Where is the renewal?
Page 18, lordship will kindly come, my lord.
Page 18, yes.
It refers to a 1986, fourth line from the top, my lord. The letter of acceptance number so and so dated 11/1986 is a prior one. Whereas in terms of the provisions of clause 18 of annexure A of the said letter of acceptance dated 11/11/1986, the licensor has agreed to grant, transfer, and demise unto the licensee a plot of land measuring approximately 5 acres in railway premises of Lokhipur Mauja, district Malda in the state of West Bengal, a license for a further period of 10 years with an option to renew the license as mentioned therein for the purpose of manufacturing and supply of monoblock sleepers. Now, lordship kindly come to page 19, my lord, clause 3(2). This again, my lord, mentions the tenure of 10 years. And lord, kindly
page
come
19.
19,
yeah.
P, Roman 2. The 10 years is again mentioned here. The previous one also mentions option to renew.
Page 21, 7%. Page 21, clause 14.
Where's the
license
renewal? Where's the renewal?
I'm showing it, my lord. Annual license fee was 64,495 with clause 14 saying 7% annual enhancement every year. Clause 14 at page 21. Then, my lord, in 2017, after my lord, it expired, my lord, I continued not paying the rent at the enhanced rate of 7%, and they also, my lord, received the rent by issuing rent receipt at the, my lord, enhanced rate of 7%. That continued, my lord, till 2023.
24, 25.
Lordship will kindly come to page 42, 33, 34, my lord.
No.
Lordship will kindly come 35, my lord. The last invoice raised by them. Page 35, lordship will find, my lord, on account of land license fee at Chamagram railway station for the period 1/4/22 to 31/3/2023. And the calculation is, my lord, done at the same rate, 7% enhancement. So, my lord, although we requested for formal extension application, formal agreement for extension, my lord, they did not consider that application filed by us. There were several applications, but they continued receiving, my lord, at the old rate. So, by conduct, my lord, there was not an
after 23, where's the receipt?
After that, my lord, we went to pay. They say that after that also I have paid.
24, 25, page 42.
Page 42, my lord.
24, 25 payment.
Kindly come to page 42, subsequent payment. This is the treasury challan. And 43. Now, they may not shoot us with a notice suddenly in 2025, first page 75, 3rd March 25, page 75, that Now new policy will apply. So the license fee shall be at a market value calculated by them. That is page 75. Kindly come to page 75, my lord. Kindly see the letter. With reference to the above, we wish to inform you that in accordance with the Railway Board guidelines, added reference 3 and joint survey conducted on 13 January 25, lease charges have been duly calculated, vetted by the Divisional Finance and approved by the competent authority. No reference to us, no calculation given. Accordingly, you are requested to arrange for payment of lease charges amounting to 1,888,090 along with GST for the period from 2022-23 to 24-25. If any payments have been made by STRESCON, kindly provide the relevant money receipt. So this is the period which I have already paid and they have issued the rent receipt. If your lordship goes back to 35, 42. This period is already paid by us and they issue the license fee receipt to us. Now they issue this letter, we object to this, saying that we are governed by the old lease which is being continued. You cannot charge at the new rate. They have not shoot us with another claim at page 107. 107. The demand rises to 1.5. Now, my lord, they add the subsequent year and the demand now comes to rupees 1 crore 50 lakhs. Page 107. We have not disputed their act of not charging this higher rate on two grounds. First ground is, that since the lease had a renewal clause, license had a renewal clause, 10 years with the option of renewal, and we continued with the possession and payment. You also accepted till 2025. Payments were accepted. So there was a deemed renewal. So up to 27 at least there shall be continuation of the earlier lease. And second ground is, that the calculation made by you doesn't disclose anything. No calculation, nothing. Just a figure is not thrown at us. Now, the guideline, master circular, which they rely upon, is at page 49. The new circular, which they say shall be applicable. Page 49. Lordship will see, at page 51, the policy 1.3. This policy shall be applicable for grant of lease, license, waiver, permission for all the cases under consideration, new cases and renewal of cases. We say, that we are not a case under consideration or new case. Now, renewal of cases, if the renewal is taken up for consideration on that day, 2017, my lease, original license 10-year expired. I continued at the enhanced rate. You also accepted. So it is not a case of renewal also right now. So you cannot invoke this policy to me at this stage. This is the dispute. We have raised the dispute, section 21 served, section 11 application is pending before this honorable court. Now, if they not invoke this letter, and if they not realize this amount, there are continuous running account bills. If they not act upon this notice, then the 1.5 crores, this demand they cannot raise at this stage. This is my case. Kindly give me some protection, because this is the dispute in the between the parties.
28th of March 2017, it has been expired. Thereafter, no formal application has been made.
No application
Nothing
made.
has been done, man. After 17, they have midway paid something. We have.
How is this maintainable?
I've made page 44 and 45.
How is it maintainable? How is it maintainable?
Any dispute in connection with the agreement?
There's no agreement.
Arbitration clause.
There's no agreement.
Arbitration.
Your agreement
No,
expires.
No, I say, my lord, that this is not a continuation of the
Nothing doing.
earlier license, which was
Nothing doing.
Lordship will kindly come to
No,
page
just
18 once.
Nothing.
Page
Nothing is
18.
here.
They have not paid that.
Nothing. You just by depositing money
No.
here and there, your rights doesn't get accrued, sir.
But option of renewal is there.
Option of renewal has not been exercised. Where is
They have
I've
to apply
exercised.
afresh, my lord.
I've
They
exercised.
have to apply afresh,
Kindly
my
come
lord.
to pages 44 and 45, my lord.
you have to apply afresh. Where have you applied?
Lord,
Where
pages
is it
44.
extended? You show me where has it been extended.
They have slept over it. We have made the application.
What have
for
you done?
extension.
Where is the application? Where have you sent your reminders? Where is it?
Page 44, followed by page
Nothing, sir.
45.
Nothing is here.
Page
Not
44 and
maintainable.
45, my lord.
Not maintainable.
And not so far as renewal is concerned, if not there is a clause for renewal.
Not maintainable.
Parties,
not
this is a case or not by action of parties, by conduct, not it has been
Nothing has been done.
because they have accepted, my lord, the
Nothing has been
renewed rent. They have accepted, my lord, in terms of the agreement.
We all know how it gets accepted. Nothing is
Sir, my learned friend's suggestion, my lord,
Even
that
your
there is
section
no
11 will not be maintainable. That will be dismissed.
But kindly
There's
consider
no
this.
agreement.
They are
Nobody can
saying that
appoint
there
an
was no
arbitrator
prayer for
also.
renewal. That is incorrect. I have shown to your lordship.
Nothing is here, Mr. Banerjee.
Pages 44 and 45.
Sorry, nothing.
That is not my prayer for formal agreement for renewal.
Sorry, Mr.
But in the
Banerjee.
meantime, they continued, my lord. By conduct, my lord, they have accepted the rent and my lord, allowed me. And my lord, this my lord, this is not a normal license, my lord. This is a license in connection with the previous agreement. I am to supply.
Previous agreement is gone. There's no agreement.
No, 86 agreement will not continue. So far as not supply of concrete sleepers, that continues.
Yes, no land agreement
And
is
this
there.
is in
10
connection
years,
with
it's
land.
over.
That agreement says I will get a land from them. A separate license agreement was executed.
Yes.
My lord, after 17, my lord, no formal agreement was there. He has not applied for that huge rent is dues, my lord. They have not paid the amount, my lord. It cannot be continued, my lord, unless and until they apply afresh, my lord.
Now, but this submission that no prayer for renewal, that is incorrect. I have shown your lordship.
Let the file their reply.
No, not turned down. Never.
Nothing
they
here,
show it?
Mr. Banerjee. Let them file their reply if they want. Learned counsel, the petitioner. This is not maintainable.
So far as my agreement, whether it is still in force or not.
I can dismiss it on that ground itself.
Lord, kindly consider me, Lord.
Nothing
Let them come back with the affidavit. I'll try to address
No,
the
there's no
lordship on
point.
this.
Why should I
Because of
keep it?
conduct of parties, Lord, the agreement, Lord, the renewal was invoked.
No,
In my humble submission, Lord, I am the lessee.
No, on this
At the
ground.
option of the lessee renewal. So I have, my Lord.
No, Mr. Banerjee. Nothing is here.
Well, both parties
Section 9
acted
is
in
not
terms of the
maintainable.
agreement.
Section 9 is not maintainable.
Kindly consider, my Lord, the term
No,
of the
Mr.
agreement is that 7% annual enhancement. So I have acted in terms of that. I have paid. They have also, my Lord, accepted the money and, my Lord, issued a rent, the receipt for the enhanced amount. So they have acted as per clause 12. No, not clause 12. As per clause 14, they have also acted. That 7% enhancement. I have shown your lordship every year, not 7% enhancement. I have paid
Until it has been renewed,
from
they
17
have
to 23.
accepted, my lord.
So that is my question. They have accepted.
To 25.
I have shown your lordship the receipts granted by them at page 35. Up to 23, they have issued the receipts. After that, they received the money. No receipt was granted after 23. Page 35 is their receipt.
Come back tomorrow, Mr. with proper instructions.
My lord, maybe 1 week time, my lord.
1 week.
So that I can file a report.
No, there's no point filing a report. You come back with the instructions. Keep it on 24th of February.
I'll try to not satisfy your lordship regarding the deemed renewal. I'll try to not. I'm grateful. Not if your service, we kept with the report.
We give. I'll just simply re-notify it. Let it come on 23rd of February.
Fine. He's appearing.
Lordship, in this matter, there was a section 9 which was filed in City Court, which we said that we will be withdrawing. Lordship, we filed the withdrawal application. The withdrawal order has been passed, but there is a wrong recording that we are withdrawing because an award has been passed. So we are again taking steps for the correction of that order. Lordship, 10 days time.
Learned counsel for the petitioners seeks and is granted. 2 weeks time. Seeks an adjournment for 2 weeks. Let this matter appear on 24th February.
Oh, Rashwa, I'm being led by Mr. Choudhury.
Lord, we prayed for leave in this matter. Pure construction contract, not a development agreement. We started construction. We are ahead of the time schedule. Lord, which I'll show your lordship. Lord, there is a bar chart which shows what is the progress you have to make. I will not cast up to the 6th floor. I am 2 months before time. I had to raise RA bills. After our usual contract, without work is done, work is measured. In the measurement book, both parties sign, on the basis of which I raise RA bill. RA bills are paid. 1.5 crores short. For some reason, no complaints. No, unless my learned friend Millard produces letters, I will, my lord, then concede that they have been suppressed from me. But from what I find, my lord, no complaints. First issue which comes up is that you are not carrying out safety norms. Stop the work. No particulars. Contract doesn't, my lord, indicate that what is to be done. Suddenly, my lord, they stop the work. Then it leads to, my lord, two letters. Suddenly some disputes, my lord, which they allege, which are frivolous, I'll show your lordship. And, my lord, contract is terminated. Now, I am a construction contractor. I've got 1.5-2 crores outstanding, plus, my lord, a claim for damages. This is work done, plus damages for wrongful termination, loss of profit, etc. This is not specifically enforceable. I have to, my lord, concede to that. The usual order, my lord, is that surveyor to be appointed to assess, my lord, what work I have done. My raw material, my lord, I should be allowed to move away. I'll show your lordship the clauses. Until that is done, my lord, nobody should be allowed to construct. Should not take more than 7, 10, 15 days. So this is, my lord, my petition and nothing more. Lord, please have a look at the contract first. I'll only show your lordship what is relevant. Page 46, my lord. 15th February 2025. Clause 2, my lord, is the total contract value 9.65 crores. Clause 11, my lord.
Work order, right?
Yes, my lord. These are accepted. These are the terms. My lord, it starts from, my lord, 46, work order for construction of a B plus G plus 11 plus 3 extra floor storied commercial building, Sector 5, Salt Lake. Then, my lord, terms and conditions are from 47. Lordship will see, my lord, the commencement date, which is 1st March 25.
This will expire on 18 January.
540 working days. Mobilization advance 5%. Payment mode 7 days from submission of bill. That's, my lord, important. Please have a look at clause 11, 13 and 19. 11, my lord, is frequency of RA bills. Contractor will submit bill 10th day of every month with detailed measurement sheet, and the bill will be paid within 14 days. Your detailed measurement sheet is signed by both parties.
Part of the RA.
It's part of the RA bill. Then, my lord, 13, payment of RA bills 95% after deducting 5%. Then, my lord, submission of RA bills. Then submission of final bill. We haven't, my lord, come to that. Now, my lord, clause 16. There is a retention amount from interim RA bills, which is 5%. So, my lord, this is, and then the
19 crore.
and issue of materials, my lord, is clause 19.
Purchase by contract.
All material will be supplied, purchased by contractor as per specification.
Price.
So, my lord, the material is mine.
Price.
Now, my lord, there are 10 RA bills, my lord, which have been raised. Now, my lord, 10 RA bills which have been raised.
55.
Please have a look at, my lord, page 361.
361.
361. My lord, this is the structure schedule, the bar chart. Please come to, my lord, serial number 6. This is to show your lordship that I have not delayed.
This will take some time, right?
10, 15. Lordship will come back.
I'll just. This needs a break.
Yes.
Lordship, he's just coming. Let me just place till he comes. Mr. Chaudhary was showing the bar chart to show that we are ahead of time and there is no default. Your Lordship, kindly take page 361, volume 3.
Volume 3. 361, huh?
361. Lordship will see this has been signed by both the parties, or the petitioner and the respondent. Your Lordship will see the serial number 1 to 6. The date, starting date and the end date has been mentioned for first floor, second floor, third floor, fourth floor, fifth floor, and sixth floor. Lordship, we have constructed till the sixth floor slab. And Lordship will see the end date is 12th of March 2026. So this was the date within which we had to complete the sixth floor slabbing. And Lordship will kindly come to the site inspection book now to show that we are ahead of time, 2 months ahead of time, page 357. Now she will see 7th of January 2026, signed by both the parties for cistern and the petitioner.
কি দেখাচ্ছ?
আরে বার চার্টটা দেখালাম, তারপরে এই সাইড
Lordship is column 6 of the bar chart. 6th floor slab has to be cast, my lord, by 12th of March 2026.
Right.
Now, my lord, please see the progress I have made, which is, my lord, page 357.
Yes.
7th of January date.
On the top, my lord, is the date, 7th January 26. Subject, 6th floor slab, checked.
2.5 months ahead.
Slab level, more or less, okay. Not stated last minute, the props are to be stated right, whatever. And it's signed by, my lord, both parties.
Yes. 2 months, 2.5 months ahead.
And the important, my lord, is that this is 2.5 months, almost 3 months, my lord, before schedule. Now, my lord, we've raised 10 RA bills. A sum, my lord, of 1.5 crores odd, my lord, is still due. I have annexed all the RA bills. I have, my lord, given
देखो ना ऑन करूँ
Prayer B. P1 is below inventory under receiver. 2 is below remove inventorized material. And 3 is below appoint an engineer or surveyor for detailing the extent of work done. And below prayer C is an injunction allowing third party to intervene until this is done. If that until part your lordship would add and limit, my lord, my prayer. Rest, my lord, I don't think I should ask for on the first day.
Yes.
My lord will kindly come to page number 49, my lord.
So what are you aggrieved by? They have already done their work.
Yes, they have
They have
done, they have
actually
tried to do their work, but there are a lot
Why
of.
don't you resolve it, madam?
Yes, my lord, we are ready. We have already
What is the
told them
difficulty?
to take away their stuff. They have not made any attempt to take it. Hence, we have put
We'll
the
record
site
your
under
submission.
lock and key.
We'll
My
record your
lord,
submission. We'll appoint an receiver. We'll
my
record
lord,
your
that
submission.
is
They
the
are ready.
requirement, my lord. Both the part in the presence of both the parties, and if my lord says, then in the presence of the site engineers of both the parties, as well as
Yes.
if my lord says the advocate on record of both the parties.
Yes.
The
That's a very
inventory
fair,
a list of inventory has already been annexed, my lord, and given by them.
fair suggestion.
By the letter dated 27/1/2026.
So you don't want to go ahead with them anymore, right?
No,
That's a decision.
that's a decision.
All right. So
And
let,
we have also issued
let them take away their stuff from there. The inventory in the
Let the
presence of both the
inventory be
parties, the
put in the-
inventory will
yes.
be made.
Yes.
And
And
go
if
before
both the
get
advocate
the arbitrator
can be
appointed.
present.
The only
And my lord, we have also served a notice under section 21 yesterday by email and today
That's excellent.
invoking.
You know, I was only.
My lord,
No, I am agreeable
one
to.
minute.
Yes.
My lord, the list of inventory has already been given by them. So let in the presence of the parties as well as the site engineers, and if my lord deems fit, then in the presence of the advocate on record of both the parties. As regards as the leisure entry is concerned, we have given them our entire leisure entry, showing that we have already made advance payment of 5.99 crore, out of which a sum of rupees 3 crores and odd has been used, and the rest is still with them, my lord.
Those
So
are a
that is
matter
a
of
matter of arbitration,
arbitration.
my lord.
Right.
That is a matter of arbitration. We have kept it under lock and key because we do not have any malicious intentions, my lord.
Excellent.
So let it be done.
Lord,
But on
may I
any
just-
my lord, within this week.
Yes, Mr.
May I just consult my learned
Yes,
friend?
please.
বাকিটা করতে পারবে না একটা 1% করে না জুনিয়র মেম্বার আমি অ্যাডভোকেট অন রেকর্ড যেতেও পারবে না হারানো পারবে না
Na Paran Parbe. I have the office of the advocate on record. Anybody? The office of the advocate on record. My advocate on record is ready and willing to be there. my lord.
instead of my lord both advocates being appointed my lord as a special officer
My lord, I
junior
don't
member
have anything. My only request is let anybody from the office of the advocate on record, if the advocate on record himself
আমি
is not
কাউকে নমিনেট করে দাও না
personally
তাই হয়ে
present,
যাবে
be there in this weekend or any day before even this weekend, if my lord says.
করে দাও
We are
very well my
suffering
lord
damages, my lord.
very well my lord
We are suffering
what
damages.
we'll do is my lord actually very small my learned friend and both my learned friends my lord there's nobody else they will nominate somebody like my lord in the office
From the office,
so we'll
nominate
and my lord they can
appointed authority.
they can both be my lord joint special officers and clients should be present
Client will be present. Both
And-
parties will be personally present along with their site engineers.
yes and remove and in case my lord there is a difficulty with respect to the measurements then my lord we'll have to come back before your lordship or maybe an independent engineer can also be
See,
there
both the site engineers, my lord. Let them record
site
everything
engineers,
first. Let everything be recorded first, my lord. Let both the site engineers remain.
very well my lord. কত তুমি খাটখাটি না দেখো তুমি এটার নামটা লিখো তুমি বলো না
My lord would kindly fix it up any date within this weekend, my lord, because we are also suffering demurrages.
Then let my learned friend will also agree to my lord an arbitrator who will finish this in 2-3
Let's finish it.
Already proposed the name of an arbitrator in our
তার নাম-
letter.
তার নাম দিয়েছে
Shailendra Jain.
না, সেটা না তার অন্য কাউকে তুমি বলো কোর্ট অ্যাপয়েন্ট করে দিই কোর্ট অ্যাপয়েন্ট করে দিই retired judge somebody will not
Yes, why don't we get a retired judge if you really want?
quick if you
Both of you can decide.
We can decide it and
Both
come
of
back.
you can.
Jyotirmay Bhattacharya?
I have to take instructions. Right now,
Ask him now. You suggest.
You suggest.
You suggest now. Suggest a name to which I cannot
Correct.
have an objection to.
Suggest a name.
No, not him. Or it should be too old, otherwise excellent. Somebody who's younger and IP. You see. IP কে করে দিন।
হ্যাঁ ঠিক আছে করে দিন।
Justice IP Mukherjee. None? হ্যাঁ চলবে। না ওনার রাজি হচ্ছে। Are you okay with Justice Mukherjee? Yes, ঠিক তো? তুমি বললে তোমার
Take down.
কথা কেউ
হয়ে গেল তো তোমার চাই।
The petitioner in the present petition, the petitioner had preferred the present petition under Section 9 of the Arbitration and Conciliation Act, seeking an appointment of the special officer for preparation of an inventory, preparing the inventory of all the materials belonging to the petitioner, lying at site, and material particularized in Annexure Z, and all other prayers mentioned in the prayer clause of the present petition. It is the case of the petitioner that the respondent had issued a work order dated 15/2/2025 for construction of a multi-storied commercial building comprising of B plus G plus 11 plus 3 extra floor storied commercial building at plot number J5 block GP sector 5 Salt Lake Electronic Complex Calcutta 700091. Full stop. The project was to be completed within 540 working days, commencing from 1/3/2025. Full stop.
Phone number.
The contract value of the project was 9,65,00,010. 9,65,00,010 only. 9,65,00,010. Full stop. The payment of bills after deducting 5% amount towards retention amount were to be made by the respondent to the petitioner within 14 days from the date of submission of the articles. Full stop. As on today, the petitioner completed 6th floor slab.
No, never.
6th floor, right? 6th floor slab roof. Full stop. The petitioner had raised invoices amounting to rupees 58046,099.04, out of which the respondent have paid rupees 442,03843. Full stop. It is the contention of the petitioner that after deducting TDS and retention money, the balance amount comes to rupees 1,890,729.58. In addition, retention money amounting to 5% of the works done, bill value raised in terms of the work, order amounting to rupees 24,59,580.47. Remains due and payable to the petitioner. Full stop. Learned counsel for the parties does not dispute the work progress and that the petitioner has completed the work ahead of the schedule. Full stop.
So I have a dispute in this. They may have completed.
Learned counsel for the
before that,
parties
but
does not
in
dispute
accordance to the work order.
the fact that the 6th floor slab has been laid.
And my lord, my
Full stop.
leisure is.
I'm not getting it.
My lord, we have a dispute regarding the amount, my lord. My lord has recorded
Yes.
their submission regarding the
Yes.
amount.
Yes.
But they have annexed our letter dated 28/1/2026 in their
Yes.
volume
Two.
4, but they have not enclosed the leisure, annexed the leisure which was enclosed with our letter. So I would like to bring that before my lord.
Page?
No, they have not.
They have not annexed.
They have only annexed the letter, but not the leisure which was enclosed. So if my lord will kindly permit, I can just bring it right now for the recordings, my lord.
Can you come after lunch?
My lord is on. Yes, my lord.
Yes.
Just one.
Come
line.
after lunch, then I'll record that. What is this?
This is the leisure which was enclosed with our letter, which has been annexed in their volume 4.
Then you come up with that letter after lunch. We'll record that. You will record your objection, and then we'll say that the parties have agreed.
Yes.
To appointment of so and so.
Yes.
Between the parties, and then arbitration will refer it to arbitration.
Yes. I'm obliged, my lord.
You come after lunch.
Yes, my lord.
After lunch, we'll complete the order after lunch. Next.
Affidavit of service.
We'll complete the order after lunch.
Yes, my lord, I appear on behalf of the respondent. My lord, it was heard by your lordship on the last occasion.
Yes.
My lord, subject
The
to
names which
my-
we have got, I'm appearing for the petitioner, my lord.
My lord, subject to lordship's kind sanction, my lord, may I submit? Whatever it may be, the arbitrator may be appointed by your lordship, any retired judge of the High Court.
We have, my lord, may we hand it over?
My lord knows, my lord, they will hand it over. Again, my lord, I will hand it over. But
Well, we also have, my lord, two
Both of
former.
them agree to and
We have given names of two former judges also, my lord.
we have, my lord, the submission with regard to
The-
that, my lord, any.
IP Mukherjee.
My lord.
My lord, any name from, my lord, leaving aside those two names, my lord, because, my lord, they have submitted for such reason, my lord, I am submitting. I am beseeching your lordship. my
Just
lord.
because we have submitted.
No, my lord, that for such reason, my lord, I have told, my lord, submitted before your lordship.
Justice Bhattacharya. Jyotirmay Bhattacharya.
I'm sure my learned
names
friends will not
upon
object to
instruction,
these names.
any retired judge of the High Court, my lord.
Oh, my lord, the first name that we have given is a technical person.
They don't want
That
that.
because 34 crore.
And I
is
know
the-
you will not agree to. I'm not even saying it. You tell me any.
Honorable Justice Joint Bishar.
But may I leave it to your lordship, my lord, because we have taken.
My lord, one after another name will come.
It will be better if your lordship, my lord, because otherwise we have given the names. Because these, my lord, these names, your lordship knows, my lord, the former chief justices, and that is why we have given the names. Leave it to your lordship, my lord. I'm sure my learned friend will not have an objection to these names.
No, my lord.
It's his client,
but
but I don't know.
Yes,
then-
my lord. Client, my lord,
I
is
know,
having the objection,
But-
my lord.
But
Jointo Bishwas,
Yes.
you have any problem?
since it will be on consent, my lord, maybe take instructions and come.
Yes, yes,
Because
No,
otherwise,
consent only.
indeed, that is the reason, my lord.
So you want to take instruction?
Yes, my lord. May I suggest this, my lord?
We'll have it after lunch. You take instruction.
My lord. My lord, I think that
Come back after lunch.
we will.
My lord. ठीक है जी?
And in these things, you should make my life
I understand
easy.
that, my lord. It's
both
only
of you
because
talk outside. Give
that
me
is
a
why we
name.
had given these names, my lord.
He's not. He has some issues. Let's work out a
Lordship,
name. Please come back. Come
My
back
lord,
with a name.
We will.
24 is my application.
Lord, I was addressing your lordship. We've prepared a small compilation.
My lord, I am vehemently objecting to that.
Vehemently
My lord,
object.
yes, my lord, because my lord,
Let
the
us see.
37 application before your
Sir,
lordship
why not
is
objecting? Why
regarding.
vehemently objecting?
No, why should
That is
I?
the question.
Because my lord,
Isn't your objection enough?
it might not feel so.
Is it possible to make a soft
when,
objection?
When nobody objects, we tend to write vehemently opposed.
My lord, the application before your lordship is regarding an interlocutory application. My lord, I am led by Mr. Sen.
Yes, Mr.
They are trying to, my lord, abar dichhe.
But I think, my lord, your lordship is hearing the appeal. Appeal has to be only on the basis of the documents in the interlocutory application before the arbitrator. I have disclosed all the documents, the section 17, objection, reply, supplementary affidavit, rejoinder, whatever there is, which is restricted and which is part of the records of the Section 17 proceeding. Beyond Section 17 proceeding, my lord, I do not think, my lord, anything can be relied upon.
While arguing, I have referred to, my lord, entire arbitral records.
Of course, whatever it is, you can, but you cannot. If I can point out only those documents which were before the arbitrator, insofar as 17 is concerned, that is there. Beyond that, my lord, we have our objections. My lord, it is after all an interlocutory matter.
Yeah, all that I want to, my lord, show your lordship today is the interim order passed by court. The order. Interim order extended by the learned arbitrator.
To that extent,
Then I will show your lordship.
Mr. Chaudhary, to that extent, I do agree with Mr. Sain that we are only confined to the Section 17 application.
So whatever I argued while arguing Section 17, I have also used arbitral records. So to that extent, I am not going to do a mini trial.
Subject to correction, all those are part of the appeal. I have
Some
taken
of the orders are not.
Well, let him point out which orders are not.
See, let us
he cannot
appreciate this.
expand the scope, and I have restricted.
What is he filing?
I don't know.
What are you filing?
So some arbitral records, some minutes.
No, my lord, everything cannot be gone.
And some affidavits already there.
No, affidavits which are not part of Section
certain
17
things
cannot be.
Certain things the learned arbitrator was aware of, which I could refer to.
Personal knowledge has no role to play here.
No, what he is saying is that since the arbitration is not pending here, this court doesn't have the entire arbitral records which was available before the arbitrator. So to assist this court in terms of those arguments, he wants to file this.
Suppose, my lord, the
arbitrator, I could tell the learned arbitrator that, sir, you will remember, he's acted in contempt of court by executing a deed of conveyance in flagrant violation, and then you passed an order of receiver over the property.
I have referred to
it. No, you may have referred, but if I say this to your lordship would want details. So what am I disclosing? I'm disclosing minutes.
No,
I'm disclosing orders. That's all.
But I will show your lordship from my compilation. All those are part of the records.
All orders are part of the records.
Most of the orders which
I'm not concerned about most.
Very well, my lord.
Most
I will
it is
refer. He will point out.
Yes, let him refer. I will.
He will point out, and if you can't, then I'll show it from here.
Absolutely.
If it is not referred by the arbitrator, if you have not yourself referred in the hearing,
Mr. Sain, this is unfair. This is unfair to the extent that whatever has been argued before the arbitrator, I am not aware of that. I am not privy to it.
Well, it is part of the affidavit.
If it is any document which is being brought by Mr. Chaudhary is also not something which is beyond the pleadings. See, you have to understand that the learned arbitrator is better aware of the proceedings than I am. Because I am only listening to the 17 application which has been decided. During the course of that argument, probably more documents would have been cited.
I am sorry, my lord, there was no document cited which is not there.
We'll see that. You make your submissions, we'll see that.
Yes. So, my lord, I'll
If there's
actually
anything-
make it extremely short, 10 minutes. I'll try to, my lord. If I expand by 5 more, that's a different thing. So, my lord, there is an order which is passed by the Section 9 court. My lord, please see the order of the Section 9 court. This, my lord, my learned friend would. Now, if it is there, we'll refer. It's dated 24th April 2023.
So the impugn order is here.
Yes, this is, my lord, the order of the Section 9 court.
All right.
I will give
Where
you
is
the
it?
page.
Is it on record?
Yes. My lord, it is page 8 of the supplementary affidavit.
Do bhai.
No. 24th April?
24th April.
It is page 8.
Yes.
No, this is in the background of me terminating development agreement power of attorney. Henceforth, all sale or alienation of flats, shops at the scheduled property with third party can be effected, making the petitioner as confirming party in all instruments covenants, and out of the transaction, petitioner shall be entitled to get 40% of sale proceeds until disposal of Section 9 application. Now, this order is continued by the learned arbitrator on the first sitting of arbitration. Lord, please see page 143 of the stay petition, volume 1.
143.
Yes.
Volume 2.
Yeah.
Yes, volume 2. I'm sorry, my lord, volume 2.
Yes.
Lord, right at the end, my lord, at 149, the order, my lord, is quoted. And it is continued.
Volume 2.
Lordship will see that. So, my lord, unsold inventory could be sold. We would participate. He would take, my lord, 60%. I would take 40% in terms of, my lord, the development agreement. Now, this, my lord, this order was continued. Now, please see, my lord. Now, this is where I will have to travel beyond. On 1st and 2nd August 2023, he executes sale deeds for 3 flats without informing me and without paying me.
That isn't taken into consideration.
Yes.
He, my lord, says that I'm justified in doing so because you were not cooperating with me. But that doesn't mean that he becomes the court and, my lord, he modifies the interim order.
Yes.
In my defense, I say that unless you give me agreement for sale, you can't blindly ask me to blindly go to the registry office and sign. I must know, give me the draft, give me the agreement for sale, and then test me. But, my lord, he doesn't put me to the test. He, my lord, executes 3 documents. I file a section 17. Learned arbitrator, my lord, I remember, observed that there is no use. This is a commercial transaction. Forget about anything else. He will pay you. Let things proceed. We agree. My lord, some demand drafts are given and we proceed. But the fact is, in this regard, my lord, let me show your lordship the 16th August 2023 minutes. Lord, please see page 150 of the stay petition.
There's a second hearing.
Yes, second volume.
Order number 4.
Yes, order number 4. We met some 20 times before the trial started on these issues. Please see page 151. The background is given. Respondent is a developer. Respondent entered into a development agreement, etc., etc. Both the claimant and the respondent have their defined shares in the ratio of 40-60 in the sale proceeds. Modality, my lord, was agreed. Disputes differences. Then, my lord, the section 9 order. Lord, please see 152, third paragraph. This is after the orders.
Yes.
Thereafter, correspondences were exchanged between the parties regarding execution and or registration of some of their deeds of transfer for transferring some of the flats in the building to the prospective buyers. Fact remains that 3 deeds of transfer were executed and registered by the respondent for transferring 3 flats in the building to different buyers, despite the claimant did not execute those deeds, though it was arrayed as a confirming party. Under such circumstances, claimant has submitted an application under Section 17 of the Act seeking interim relief in modification of the order dated such and such passed by the tribunal, so that the respondents are unconditionally injuncted from dealing with or disposing of such and such. Respondent application under Section 17 from restraint. They filed an application to restrain us. Now, my lord, please see page 153. This is the ordering portion. And it was second paragraph. Though the tribunal finds that there are some disputes between the parties with regard to the exact consideration money paid by different purchasers, still then the tribunal feels that the buyers who have no interest in this litigation should not suffer, which is not what prompted the learned tribunal to pass this order. The one respondent is directed to pay 40% of the total consideration money paid by the purchasers in respect of the last 3 transactions which were made by the respondent in favor of the 3 different purchasers. Correct. Which were made by the respondent in favor of 3 different purchasers. One of transactions made by sale deed dated such and such, 2 others by sale deed dated such and such, by demand draft in favor of the claimant within 15 days. Not very important. First sentence, the respondent is directed to pay 40% of the total consideration. Clear direction. He does not, even today, pay me 40% of the consideration.
Are you
sure? Yes, 100% sure. What he says,
the additional these 3 flats which have been sold, right?
yes. Now what he says, my lord, I remember in arbitration they said we'll pay you, forget about all this, we agreed. It's a commercial matter. What he now says is, so my lord, he's paid around 3 crores from the beginning of the transaction in ad hoc payments. So he goes back to the learned arbitrator and tells him that, look, of the money which I had to pay, say 1 crore I had to pay under these 3 deeds. Out of that, 30 lakhs I have already paid him earlier because I had taken the money earlier under the agreements for sale. So he's never given me particulars.
So this is more like settlement of account. I mean, you know.
So, no. He's frustrating. Lord, I want to show your lordship why 2 things. Why the learned arbitrator passed an order of blanket receiver over the flats with the receiver to sell, and why, my lord, it is not double security as, my lord, they are, my lord, submitting before your lordship. So what happens is, my lord, on this day he could have told, my lord, the learned arbitrator that total consideration is 2 crores, out of which he has already received 30 lakhs. So I am going to pay him another 30 lakhs. He doesn't. Learned arbitrator exonerates his conduct by, my lord, directing payment of 40%. He takes, my lord, a time for that. Within that time, he pays 0 rupees. Beyond that time, he pays a pittance and says that, look, the rest I have already paid you. This is conduct number 1. This is paying fraud on court. And I'll show your lordship the letter also. This is why he doesn't want all this to come, because learned arbitrator is fully aware. So, my lord, I'll read.
After lunch?
Yes, my lord. Lord, may I come back at 3 o'clock if your lordship permits? Or I have a writ petition at 2 o'clock fixed after a lot of mentioning, effort and pleading before the court.
Okay. What about that section 9?
Yes, there also I mean, but then I'll come here. And
that section 9 either, then you keep your junior here or?
Yes, I'll do that. My learned friend can, I'll just come and quickly come back. Or I'll try to be here after the section 9 to continue with this.
With regard to item number 23, my lord,
We've got the names, my lord.
there are two.
We are in consensus with both the names, my lord. Any name that your lordship is pleased, my lord.
Ashok Chakraborty, my lord.
Ashok Das.
Ashok Das Adhikari.
And my lord, this is stop, my lord. Any name.
Any name.
File them. Take down the petition and the present petition. The petitioner preferred the present petition under section 14 of the Arbitration and Conciliation Act 1996, challenging the unilateral appointment of respondent number 2 as the sole arbitrator to adjudicate the dispute between the parties. By respondent number 1 and praying for appointment of an independent arbitrator in substitution of the current sole arbitrator
That can be disputed by him.
who is former employee of respondent number 2. Learned counsel for the petitioner states that learned counsel for the respondent states that he has no objection.
This part, my lord, may not be written.
Then I'll set it. I'll set it aside.
Yes.
Learned counsel for the petitioner submits the dispute have arisen between the parties. Full stop. The petitioner had invoked the arbitration clause contained in the contract by issuing a notice dated 2nd of August 2025. 2025, yes, full stop. The respondent, however, by its reply dated for 15/9/2025, failed to accede to the petitioner's request for reference of the dispute to arbitration. Full stop. Consequently, the petitioner filed an application AP number 878 of 2025 under section 11 of the Arbitration and Conciliation Act 1996, and the same is pending adjudication. Full stop. It is further submitted that during the pendency of the AP 878 of 2025, full stop, the petitioner unilaterally on 4/12/2025 appointed respondent number 2 as the sole arbitrator to adjudicate the dispute between the parties. Full stop. Being agreed by the unilateral appointment of the sole arbitrator during the pendency of the section 11 proceedings in AP number 878 of 2025, the petitioner has preferred the present petition challenging the said unilateral appointment. Full stop. It is no longer ethical. In this context, the petitioner relies on the judgment of the Honorable Supreme Court in such and such, wherein it has been held that the unilateral appointment of the arbitrator give rise to justifiable doubts as to the independence and impartiality of the arbitrator, and such clause is in violation of Article 14 of the Constitution. Full stop. Applying the aforesaid well-settled principle of law to the facts of the present case, this court is of the considered view that the appointment of respondent number 2 as the sole arbitrator is in contravention of the settled principle of law, and the said appointment is set aside. Full stop. At this stage, learned counsel for the parties jointly submit that they are agreeable to the appointment of Mr. of Justice Ashok Das Adhikari, retired. This is fine, right? Retired as the sole arbitrator to adjudicate the dispute between the parties in view of the consensus arrived at, comma, the matter is accordingly referred to the learned sole arbitrator for adjudication, full stop. The learned sole arbitrator shall be at liberty to determine his remuneration and conduct remuneration in accordance with Schedule 4 of the Arbitration Conciliation Act 1996, and shall conduct the arbitral proceedings in accordance with law, full stop. The parties are directed to forthwith communicate the copy of this order to the learned sole arbitrator, full stop. It is clarified that this court has not entered into the merits of the claim, nor claim or counterclaim, nor expressed any opinion on the merits of the matter. All the issues are left open to be adjudicated by the learned sole arbitrator. Full stop.
Deeply obliged. Deeply.
I'm grateful.
My lord, item number 22.
Disposed of with the above direction.
My lord, I was drawing my lord's attention to the leisure.
Yes.
My lord, they have already annexed this letter of mine at page number 569 at volume 4, but have maybe
Sir,
forgotten
26.
to
Yes.
569, volume 4. My letter dated 28/1/2026 has already been annexed as the last annexure. And if my lord will kindly come to the last page, I have,
Yes,
it
it's
is
there.
typed enclosed copy of your leisure account marked as annexure A. But somehow maybe they have forgotten to annex the leisure, which my lord I have right now placed before my lord. My lord will from the last page see that
Yes.
5 crore 99 and odd have already been paid to them, out of which they have used 3 crore and odd, and 2 crore 35 and odd is still lying with them, my lord, for which I have been reminding them to raise pro forma invoices, which they have failed to do till date, my lord. So my lord will kindly record this as my submission, that I am disputing the construction, and the
amount.
accounts. And as regards the inventory is concerned, my lord, they have already annexed their list of inventory at page 534, my lord.
Yes.
565.
At page 534, volume 4, my lord, the list of inventory along with their letter dated 27/1/2026, my lord.
Hey, who was taking that? तुम्ही ले लेते.
हाँ, এটা কি আছে?
I wonder how, my lord, a contractor can then the work done.
So, my lord, as regards the inventory is concerned, we have already agreed that both
Those
the
are, I'm
parties
not,
will be present
I'm
over
not
there. So, I
getting
am
into
not
that
pointing
dispute.
that
I'm
out,
only,
my
yes.
lord. I'm not
But
pointing that
I
out.
am not addressing on these contentious issues at all.
I can't even adjudicate these.
Why would I
This will
disturb
go
your
before the arbitrator, whatever it is. Yeah, clarify last. उससे पहले क्या है? उससे पहले हम्म, हम्म, ठीक है, उसके बाद लास्ट लाइन ये उसको हटा दो. Also remains due and payable. Full stop. The petitioner where's that letter of 8/1/26?
6. It's page 524. 524.
The petitioner on 8/1/2026 received a WhatsApp message from the respondent asking the petitioner to stop the work immediately with effect from 9/1/2026 and asked them to submit the updated bills. Full stop. The petitioner stopped the work with immediate effect and submitted the updated bills. Full stop. While letter dated 13/1/2025, the respondent issued another letter dated 13/1/2026 citing safety reasons, right? 13/1 safety reasons.
Yes,
only.
yes.
13/1 safety reasons and asked the petitioner to stop the work with immediate effect. Full stop. Thereafter, settlement works settlement discussions were taken. Settlement talks were underway between the parties, and the petitioner was further allowed to perform the work. Thereafter, while letter dated 23/1/2026, the respondent called upon the petitioner and its staff to vacate the said site and thereafter stop the electricity and water connection. Full stop. It is the contention of the learned counsel for the petitioner that an outstanding amount of rupees 319,60054. It is the submission of the petitioner that the materials amounting to rupees 319,60054 is lying on the site. It is the contention of the petitioner that the termination of the work was illegal and erroneous. Full stop. He further states that as per the arbitration clause, the dispute is amenable to arbitration and the seat of arbitration is Calcutta. Full stop. Learned counsel for the respondent disputes the contention advanced by the petitioner regarding the alleged outstanding amount and the other contentions. Full stop. However, without prejudice to their rights and contentions of the parties with view to expediting the proceedings, learned counsel for the respondent fairly submits that the respondent is agreeable to grant of prayer B for the grant of prayer B to the petitioner at this stage. Full stop. Learned counsel for the respondent assures this court that the respondent shall fully cooperate with the special officer appointed by this court for the purpose of preparation of inventory at site for conducting joint measurement of the work executed by the petitioner. Full stop. In view thereof, this court deems it appropriate to give one person from here, one person so and so, a special officer to prepare the inventory and conduct joint inspection as prayed for by the petitioner in terms of prayer B of the present petition. Full stop. The respective engineers of both the parties shall render necessary assistance to the special officer for carrying out the said exercise. Full stop. Learned counsel for both the parties shall also remain. You want to remain present, or the special officer is?
We want to remain present.
Learned counsel for the parties shall
As
also
well as the site
remain present at the
engineers.
site
And both the site
during the
engineers
execution
also.
of the assigned work. Engineer, I said
The
that.
site engineers of both the parties.
They will assist the special officer in taking the measurements.
Yes, I'm obliged, my lord.
Will remain present at the site. Full stop. The special officer shall we give some money to the special officer, or the
No,
client
not
will take
required.
care?
Not
All right.
required, my lord. Not required, my
All
lord.
right. Learned counsel appearing for the parties. At this stage, learned counsel for the parties
My lord is
state that after taking instruction from their clients, jointly state that this matter can be referred to arbitration, and that Honorable Justice I.P. Mukherjee, retired, can be appointed as an arbitrator to adjudicate the dispute between the parties. Full stop. In view of the said submission, this court appoints Mr. I.P. Mukherjee, Honorable Justice I.P. Mukherjee, retired, as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The arbitrator shall be at liberty to fix his remuneration in terms of Schedule 4 of the Arbitration and Conciliation Act 1996. Full stop. It is further clarified that the special officer, that after completion of the inventory,
within a specified time, my lord.
it is further clarified that upon completion of the inventory and joint inspection, the special officer shall place the same before the learned sole arbitrator, his report, within a period of
3 months.
2 weeks, my lord.
4 weeks.
6 weeks.
My lord, but the inventory should be done within 2 weeks.
As a the inventory will be prepared within 2 weeks.
2 weeks.
And the same shall be submitted before the learned arbitrator after the constitution of the arbitral tribunal.
The survey method, it will take around 4-6 weeks.
No, my lord.
Yes,
Who will
but
support
I'm
the
not-
damages, my lord? Who will support?
We'll start conducting the survey within 2 weeks,
From tomorrow onwards, my lord, it's their
and the
site
same shall
engineers,
be
the site
completed, and
engineers.
the same shall be completed
Within 2 weeks, my lord.
within 2 weeks thereafter. Oh, it can be done. sir.
Yes, my lord. Their
Why?
site engine.
Lot of iron materials which are embedded.
You have come here to the court only for this,
Yes,
so that you can immediately remove the items. And now you're saying you want 6 weeks, 8 weeks, 10 weeks. Why?
Removal will take time. I am sure it can be.
It's your money, your material. Take it out.
I'm
You should
obliged,
do it
my
in
lord.
24 hours.
Yes, my lord.
Why have you come to the court?
Absolutely.
How can you make this submission? 6 weeks. What is the intent? This shows your intention. Why have you come to the court?
This removal will take time. That is what it is. Nothing
That is the reason why you have filed a section 9, sir.
else.
I'm obliged, my lord.
Within 2 weeks thereafter. Full stop. With the aforesaid observation, the present.
Remaining reliefs in arbitration.
Yes.
Kind of.
The learned sole arbitrator shall adjudicate all the disputes between the parties without being influenced by any of the observations made in the present order. The parties are at liberty to raise all their disputes before the learned sole arbitrator to be decided in accordance with law.
Including the other reliefs in the section 9 application. Otherwise, if I file a 17, because they say this was not granted.
I'm not sending this 9 over there.
No.
So you file your section 17 there.
Absolutely. But my lord, other injunction, relief of injunction.
The parties are at liberty to move appropriate applications before the learned sole arbitrator for adjudication.
My lord, will it be a joint report by all the special officers?
Yes.
My lord has mentioned his report.
No.
It's their report.
It will be a joint report. 2 special officers are appointed to file a joint report.
Yes.
Along with the assistance
Yes,
of
my
the.
lord. Yes, my lord.
You give it to me, I'll make the correction.
I'm grateful, my lord. Much obliged.
Disposed of. Supplementary affidavit, I'm taking the supplementary affidavit. Supplementary affidavit filed by the petitioner is taken.
My lord, my letter is also there.
It's okay. That's almost there.
Yes, my lord. Even except the ledger part, my lord.
What is your name, madam?
Monica Kalram, my lord.
Sorry, I don't know all the names, so not familiar with all the names. I try to. As much as I can do, right, Mr. Chaudhary?
Yes.
Much grateful, my lord. My lord has saved me today.
That we didn't second appeal against each other. I was very proud about the judgment because I ended up arguing for reversal of a eviction decree. After 6 months or 1 year, I asked her what happened. He said, I had that reversed in Supreme Court.
I tried, my lord. We had a nearly 6-hour long argument.
Yes. Very interesting.
Next.
Much grateful, my lord.
Grateful very much.
Salty.
Salty, my lord. Lord,
Vehement
I was, my
opposition.
lord, on breach of the first interim order of court, subsequently continued by the learned arbitrator. Then, my lord, when I file a section 16 application for an unconditional injunction restraining them from, my lord, selling off the further inventory, they, my lord, say that we'll pay you 40%. Learned arbitrator says pay 40% and carry on. They agree, never pay me 40%. And I was in the process of, my lord, reading out that letter to your lordship. Just, my lord, the 4th paragraph.
This was page.
This is, my lord, it's in my compilation part of arbitral record. It's an exhibit. I just read out. Its lordship need not, my lord, see it. Out of the dues, sum of such and such have already been paid to you when we received advances from the client.
Yes.
They have paid us 2.5 crores from the beginning. Sales of over, my lord, 60-70 crores. And now really pittance paid to us, and now they put this in. Now this is a contentious issue in the arbitration. Now this is not all. After this,
what was your section 17 application?
My lord, section 17 was for a prayer of unconditional injunction, because this order was
conditional injunction regarding
from restraining them from selling. Yes, because they
Section
agree.
7, what you read out just now is that 3 flats could be sold off. They have relied on the order which has been passed by the commercial court,
Yes.
Rajarhat court, stating that those flats could be sold off. 40% will go to you, 60% will go to
Yes, and I must go and sign, because by then
you become a confirming party.
No, my lord, I am the landowner.
No, but you are a confirming party. That was
Yes,
the order says. that
yes.
You will be a confirming.
Yes, correct. But without me, my lord, and also importantly, if I don't go and sign, sale doesn't go through because I have cancelled his power of attorney. So, my lord, he's to inform me and give me 40%. He does not. Sells off 3 flats. I now file an application to restrain him from selling off anything. That's when, my lord, he goes and commits further contempt. Sells off 2 further flats. 3 further flats.
3, then 5.
And 5 further flats. First 3, then 5.
Oh, subsequently also.
Subsequently 5 further flats. Now I filed an application for appointment of receiver. Please look at the conduct and I'll show the orders one after the other of the learned arbitrator. He goes off and fill 8 deeds of sale in contempt of court. Please see. Show me from his application. It's not there. I'll just read out orders of the learned arbitrator. Would you get it out now? If they were, I'll just take out the orders and give it to your lordship. Actually, I don't need to.
You give me that. You just point out the order.
24th April 24.
Is there?
Sure.
24.
Where are the orders?
24. এটা স্টে পিটিশনের ভলিউম 1 এই আছে।
না এটা আমরা পরে দিলাম 24th April
Not on record.
later.
Is there?
The orders have to be there.
Yes, it is there.
Where is it?
That particular order I have later handed over in the course of my submission. This is the only order which I missed. This is the only order which I missed.
Please see the order.
Yes, I have placed this order.
Claimant is the landowner.
Here is.
Respondent is the developer. Development agreement was entered into between them on 7th April for construction of a residential building. These are this is what was agreed. Then allegations of claimant, allegations of respondent. Now, please come to internal page 6. In this backdrop, present arbitration proceeding has been initiated, wherein the claimant has claimed for a declaration that the development agreement dated 7th April has been terminated and the power of attorney dated 7th April has been revoked. The claimant has paid for an award of 139 crores together with interest. Even prior to initiation, claimant filed an application under section 9 where the following order was passed. Then next page, order is quoted. Then subparagraph 3, it's continued. Then immediately after initiation of arbitration proceeding, claimant took out an application under section 17, hereinafter referred to as first section 17 application, complaining that the deeds of transfer were executed and registered by the respondent for transferring the flats in the building to different buyers without those deeds being executed by the claimant, though the claimant was arrayed as confirming party in those sale deeds. In the said application, the claimant has sought for modification of interim order passed earlier on 27th April 23, so that the respondent are unconditionally injuncted from dealing with or disposing of any portion of the proceeding. Several other interim paid for. Respondent also, their section 17. Then, subparagraph 6, after taking note of the fact that first phase of construction of residential building has been completed by the respondent, and out of 63 flats, 43 flats have already been sold to different buyers by execution and registration of sale deed, and agreement for sale in respect of 12 more flats have been executed with different prospective buyers, and execution of sale deeds and registration of sale deeds are still awaiting. The tribunal, after considering the respective rights of the parties and interest of purchasers, prospective buyers, modified the interim order which was passed on 27th to find out a workable solution, and the following order was passed. This is the first one. Respondent is directed to pay 40% of the total consideration money paid by the purchasers in respect of the last 3 transactions which were made by the respondent in favor of 3 different purchasers. One of such transaction made through sale deed executed vide sale deed dated such and such, and the other 2 transactions made through sale deed executed and registered dated such and such to the claimant by demand draft within 15 days from the date of the order. Lordship has read this. Are they, I ask myself, entitled to deduct by saying I've paid you something else? The answer is no. On payment of 40%, claimant will regularize those transactions if needed on the request of the respondent to validate those transactions as per law. So that's why, my lord, those have not remained validated till today. Then, with regard to the remaining 12 transactions, the respondents are directed to serve copy of agreement for sale and copy of sale deed in respect of each one of the aforesaid 12 transactions upon the claimant within 1 week from the date hereof, so that the claimant can have idea about the nature of the transaction being transacted in respect of those proposed transfers, name of purchasers, consideration. Then remaining 12 transactions can be completed by the respondent by joining the claimant as confirming party in the sale deed to be executed and registered, and on payment of 40%, claimant will execute sale deed. My lord, notice is also directed on the next page. Then parties have exchanged affidavits. Then, my lord, pending disposal, claimant has taken out 2 more applications. In the second section 17, claimant has paid for attachment, etc. Then, my lord, the other application under section 31, all the 3 applications of the claimant were heard and disposed of by a common order. So far as the claimant, here, my lord, may I pause here for a moment. In the statement of claim, I relied upon 2 sheets, my lord, calculation charts which they had given us. There, my lord, midway through the performance of the transaction, according to me, he has included the cash component also, which he has received over there, and he said that I should be paid so much money, full particulars up to that date. I filed a section 31 asking for an interim award on that basis, part award on that basis. They, my lord, affirmed those documents in their written objection to the section 9. They said, yes, I'm not disputing. But when I filed the section 31, they said that you managed my accountant and got these documents executed. Learned arbitrator said that very well, I'm not passing an interim award, but I will definitely secure you. And order was passed for 12 crores security, which has not come till today. Then, my lord, if I may continue. My lord, at internal page 13, while disposing of the application under section 31, the tribunal held that in the facts of the instant case, it will not be wise at this stage to pass an interim award in terms of the relief claimed by the claimant in the present application. It was observed by the tribunal that the fact that a sum of rupees such and such have already been paid to the claimant by the respondent, in addition thereto, possession of 4 flats and 8 shops are also with the claimant. That apart, still 8 flats remain unsold. Even no agreement has been entered into by the respondent with any prospective buyer in respect of those flats. Respondents have already been injuncted from entering into any agreement for sale in respect of the remaining 8 flats. Following directions were passed. No, this is also, my lord, they have to pay me, etc. All of this. Then the history continues. I file more section 17 because they keep, my lord, violating the order. Then, my lord, please see page 15, second paragraph. In the said application, it was pointed out by the claimant that the respondent in willful disregard and violation of the order passed by the tribunal on 27 June and 16th August executed number of deeds of conveyance in favor of different purchasers without disclosing those sales to the claimant, and no part of sale consideration has been paid to the claimant. The claimant has also complained that even after the order passed by the tribunal on 26 February 24 has not been complied with by the respondent. Respondent is regularly trying to execute sale deeds in favor of purchasers in violation of the aforesaid order of the tribunal without disclosing those transactions to the claimant. The claimant apprehends that if the respondent even succeeds in transferring the remaining 13 flats in the building and appropriates the entire consideration, claimant will be absolutely helpless in recovering its legitimate dues. Under those circumstances, application has been taken out, praying for appointment of receiver. After 5 acts of contempt, 8 acts of contempt, 8 sale deeds, and I don't want to keep reading, Milord. See, you will not be able to irritate me.
I'm not irritating.
I am
I'm
not
telling
too
you the
easy
fact.
to irritate.
I'm telling you the fact that you have taken payment for all.
All right, this is one of the orders which is not there. Any other order which is not on record?
Yes, yes. Then I'll just check.
I'll take it. I'll take your comparison on record. Give it. Give a copy to
The
them.
note. Then I'll make it.
For the judge's copy.
Okay. I'll just show orders and nothing. Oh, this is in 2 volumes. I'll make it very short and not.
The compilation file, take down. The compilation filed by the respondent is taken on record. Learned senior counsel for the petitioner raises an objection to the said compilation, stating that the entire record of the arbitral tribunal is placed before this court. Full stop. Though this court observes that the order dated 24/4/2024 has not been placed on record, the same has been handed over to this court by the learned senior counsel for the petitioner. Since this court is of the prima facie view that the entire arbitral proceedings are not filed by the petitioner along with the petition, this court is compelled to take the record filed by the respondent to enable itself to the proceedings before the learned arbiter. Give a copy to him. A copy
I've
of
given
the
a
said
copy.
set has been handed over to the counsel for the petitioner.
This has deposition of Varun Bagla. This
Doesn't matter, Mr. Sen. You should have placed everything on record.
I have placed.
I don't take over the counter orders.
But I made my argument saying that only one order has been missed.
Mr. Sen, you should have placed all the orders. Not even one order should be missing from the file. And that too an order which is relevant.
Yes, sir, I have placed that order before your lordship.
all right.
I have
That's
made,
why I'll take this into consideration. You want to challenge the order?
I have also, Milord, filed an application for Milord enforcement of orders of the arbitral tribunal. Milord, we found Lordship is aware, Milord, that it's to be challenged and it's to be enforced in court. So, Milord, we had filed it in the Rajarat Commercial Court. Now, Milord, after your Lordship's judgment, which we accepted, we have filed it here. So, Milord, see, we start with the agreement. I'll just summarize now.
Yes.
And Milord, stop. We start with the agreement, which is a 60-40 ratio.
Yes.
Developer gets 60% of sale proceeds, I get 40%. The developer is required in terms of the agreement to deposit the money which comes out of sale in a bank account. That's the escrow account, and we are to be paid. My lord, if your lordship looks at the supplementary affidavit filed by my learned friend, at page 45 is the clause.
Yes. 3.5.
3.5.
Yes.
Now, they don't. Till today, there is no bank account in terms of 3.5. Central Bank of India, Park Street branch, there is no bank account. Evidence on record will show that there are 14 bank accounts which they have opened in their name and have received consideration. 14. Because now I have the benefit of cross-examining him. So I got out, my lord, 14 bank accounts. 12, I'm sorry. My lord, if your lordship, my lord, takes the compilation, please have a look at page 1. This is
page.
I wrote this letter to them.
Which page is the letter?
Page 1. Lord, ignore it, my lord. Just see the bank accounts which have been detailed there.
Chart of the bank account.
Yes. So
9 plus 4.
Yes. And your lordship will see, my lord, below that 1 to 9 and then 1 to 9 are the dates and, my lord, the page numbers. This is of the exhibit in the matter. So all that we told them were very well, you've put in the money in 9 bank accounts or 13 bank accounts, give me bank statements. At least 10 times I asked him the question. There were letters written. He's not produced bank accounts for the entire period. So I actually don't know how much he's received. Zero transparency. Fact of the matter, to come back, my lord, is breach of clause 3.5. And I am not given what is due to me. Before, my lord, we start arbitration, 6 months or 1 year before, he gives me a statement on the basis of which I later file for judgment upon admission in the form of section 31, which is, my lord, pages 73 and 74 of the statement of claim. And this is page 79 of the stay application. See, you are so bad with page numbers. I'm sorry, my lord, it's page 79 of the supplementary affidavit. Let me just check first. Yes, this is, my lord, page 79 of the supplementary affidavit. My lord, 79 and 80 is the first chart. Lordship will please see, my lord, page 80. This is somewhere in April 22. My lord, these are the dates of the documents registered and unregistered which they have executed. And ultimately, on the second page, that is page 80, they work out a full landowner's share. Then on the next page, my lord, is another chart. Please see page 82. So I am to get, my lord, 3 crore 41. If your lordship sees page 82, at the bottom, my lord, net due is 3 crores 41. Now, they don't, my lord, pay me this money. And, my lord, we go to arbitration. Plus, they keep selling and I have no accounts. Plus, my lord, there is delay of 15 years or 10 years. 10 years, really. When we went to arbitration, after section 9, we agreed in court that we won't stop sale, because if you stop sale, both of us will suffer. Commercial sense says, very well, whatever you have done till now, I'll proceed and get my money out. Maybe I'll pay for some security. But for the future, all sales to be in terms of the agreement. That's a very legitimate ask. So that's the interim order. His, my lord, intention is to sell as much as you can and grab as much as you can and then run away. So, my lord, he sells, after that arrangement was done, he sells 8 flats illegally. First order is passed. First order directs that very well, no interim award in terms of these documents, but security for 12 crores. He, my lord, breaches that interim order also. He challenges that interim order by filing an appeal. In the appeal, he does not succeed. Appeal is dismissed. He doesn't even prosecute the appeal. Appeal is dismissed. He acts in breach of the order, doesn't give me 12 crores as security. In the meantime, what he has done is, the first order tells him to tell me and take me to the registry office and sign with me. He doesn't take me, he signs on his own. Not once, but 8 times. 8 times he signs. 8 separate acts of desperate acts of contempt. So now the learned receiver appoints a receiver over the property, over the balance unsold property, which is, I think, 10 or 12 flats for security. Now what he says before your lordship is, before the learned arbitrator first, that you are asking for double security. A, you have asked me to pay 12 crores as security. Doesn't matter that I've never paid that. Doesn't matter that my appeal has failed. That's a security order. And B, you've put double security of these flats, of these other 8, 10 unsold flats where you've put a receiver. So this is his argument. Now I'll tell your lordship, this is not even single security, let alone double security. Number 1, the first security order of 12 crores against which appeal has been dismissed, of which he's asked for modification and he's up in appeal now for modification. That 12 crore order he has never complied with. Never ever complied with. No security has been given by him today. Only thing I have now are those flats over which there is a receiver. Now those orders are also that the receiver will take steps to sell. And yesterday, before the learned arbitrator, he has filed an application for sale of those flats.
Through the arbitrator.
Through the arbitrator, I'll agree. I'll agree. Subject to checks and balances, I'll agree. So let him take the cash. But at least I'll get something out of it. Let it be sold. So, my lord, whatever now, what the conceptual mistake in this application is, when he says that there are 10 flats to be sold, and so your 12 crores is secured, he forgets that under the revenue sharing ratio under the agreement, 40% of the sale proceed is anyway mine. So it's only his 60%, and his 60% won't even cross 3-4 crores. Even if I forget my damages claim, I have a claim of at least 12 to 14 crores. And that money, my lord, even without damages, without cash, if you just look at sale deed, registered sale deeds can't lie. They're all exhibited in arbitration. You total the total consideration in all the admitted sale deeds, and you divide it by, make it 40-60. Whatever 40 comes to, I'll still have a claim of over 9 or 10 crores straight, which these flats, his 60% of these flats won't even, will not amount to half of that. Plus, I have a claim for cash, which, my lord, he's admitted in these 2 schedules. His only defense is my accountant went rogue and he turned over to you. The usual. Now, you either say this was for tax purposes, don't rely on the document, or the person who signed went rogue. So, my lord, 10-12 over there, plus cash, which is admitted. Plus, I'm going to prove cash, my lord, by showing, look at the price, average price. and look at the cash you have admitted. So for the balance, if, my lord, the disclosed price is in the same band, then the cash must also be in the same band. You're selling two flats side by side. First flat you have sold for say 1 lakh rupee check, 20,000 rupee cash. Second flat you have also sold for say 95,000 rupee check. The presumption is that you have taken 20,000 rupee cash. And if you haven't, law doesn't presume that you do such an act, then law will presume that you have deliberately sold at an undervalue, and I'll get that other 25,000 rupees in damages, my lord, in this matter. So, now this is the gory facts.
How will you prove your damages?
My lord, damages, I have a simple calculation. 2011.
How many flats were there total?
I'm sorry?
How many flats were there?
63. And my lord, here I must tell your lordship.
And initially, everything was fine, right?
For a few years, everything was fine. Now, I'll tell your lordship what has happened. This is, my lord, a large property. There was supposed to be one residential cum commercial, and the second one is exclusively commercial. He hasn't, my lord, laid one brick in the second building up to 2023, when I got an injunction. My lord, 3 dates, my lord. 2011 is the unregistered development agreement. April 2014, all mutation, etc., everything done. Your time starts. You're supposed to finish, my lord, in 3.5 years. From 2014 April to 2024, he builds, my lord, half the property. In his own sweet will, my lord, he proceeds. And what he's built, he doesn't even pay me anything. So the second fight is with the other half of the property, which is vacant land. Now, my lord, he wants to construct there. And my calculation is, this is the average sale price as per registered documents. If you had done everything in time, then I would have got my 40% in the year, say 2017-18. I will get it in 2020 something. So the interest on my capital, which is lost, is my claim and damages. My lord, may I do this?
Yes.
I have an application for enforcement of these orders, which is numbered. I'll serve the application upon him, and I'll also file an affidavit to his, my lord, stay petition. This is coming up, my lord, for the first time. You'll let him file a reply.
Your lordship is hearing the appeal.
Then I can proceed.
Yes,
I
that
have
was
no
the
problem.
understanding. Otherwise, I wouldn't have finished my argument.
Very well, very well. I'll proceed. Lord, I don't have too much to.
I am hearing the appeal.
Yes.
So, my lord, this is, in fact, this would be my submission, just, my lord, those judgments. My lord,
Then, Mr. If it is just one order, then why are you making it so bulky for me?
Yes.
and my lord, the main.
No, I'm just.
No, I will show some more. The main problem is.
Mr. Chaudhary, don't make it bulky for me. There's
too
much document in here. There's too many stuff to be looked at.
No, I am.
Why are you filing this then?
My lord, let it be. I don't want to, my lord, elaborate too much.
Then I'm not taking.
I'm sorry, my lord.
Then I'm not taking it. If you don't want to file it, don't make it too bulky, Mr. Chaudhary. It will create more problems for me. I have to read too much.
Very. My lord, I am never one who will create trouble for the court.
In the sense, I have to go through each and every document. Then.
Let it be, my lord. Leave it aside.
Strike down that order. Give me that.
My lord, if I need to, I'll show you a document. Where is the problem?
Need be, we'll see it.
I remember, my lord, that I had missed one. I had
No, there are other things.
I have
Find a
submitted it.
supplementary affidavit, Mr. Sen.
No, there are other things
Since
which I will show you.
Your lordship said very well. Otherwise, I would have given. I
filed a supplementary.
I have filed a supplementary.
I am going.
When I realized that certain things are not there. But
But,
this was missing. I came to learn that
I will. There are certain other things which I will show.
I have deliberately. I have placed this order. It is to my advantage. I have placed this order.
Put it on record.
Yes, yes. Surely, my lord, I shall file only with that supplementary affidavit.
Your conduct is excellent. It's only your client's
Let us,
conduct which
my
is
lord,
bad.
I said, my lord, when I started, the entire arbitration is proceeding only on prejudice. I must get a chance, whether it is before your lordship or before the arbitrator, to remove the cloud.
But arbitrator is giving you a chance every day.
Yes, I am still waiting for it.
Every day you argue.
No, no. I
arbitration proceedings are
of course, my lord. So if things, if
See, you can't help it. If your
things-
client is a
it is
blood
not,
contemner, you can't help it.
I'll request my learned friend that speak on the facts.
That is, I am exactly I'm doing that.
You had
Give the
filed
number.
one violation, you could not refer to any document.
Number 7 দিন 10 দিন হয়ে গেল এখনো পাওনি সত্যি ফাইল করেছো Well, I filed a contempt application, so I can call him a contemptor. And the learned judges found him to be a contemptor.
I'm a bad man. I'm a contemptuous
Yes,
man. This
correct.
order cannot stand. Still then.
This order cannot stand.
Cannot stand.
We'll see that.
Thank God I
submitted on law.
Yes.
That first principle is section 37. Your lordships, my lord, don't do a de novo hearing on facts.
I have not
in
any submission of fact.
In my lord, consonance with the principle, like in a section 34, your lordships will not only probe in a limited manner. So, my lord, for that, may I just hand up a judgment? So give me something without the para number written. My lord, I am sorry this is not done because the paragraph numbers are written on top, which I want to rely on. It should be a clean copy. Oh, sorry, I copy the Lava. 2024 9 Delhi 6908. I'll just give you a copy. Lord, please come to paragraph 12. Before dealing with these contentions, it may be noticed.
So this was
that
it, Mr. Chaudhary, that your only contention is that they have flouted the orders which have been passed time to time. And as far as the other order of 24th of whatever date was concerned, you had the sole arbitrator had given them the opportunity to sell the flats in making you a confirming party. Those flats were sold and more flats were sold, right?
24th April is receiver appointment.
Receiver appointment.
Full over the unsold spaces, receiver has been appointed. Taking consideration of my conduct, receiver has been appointed.
Milord, I'll just summarize.
Appeal is not against this order.
Appeal is not against this.
Four Milord points. Number 1, order of security ought not to be varied on the ground that it is resulting in double security. Number 1.
No, but that security has never been placed, right? That 11 crore odd.
Yes, it's never been placed.
It has never been placed.
My lord. So that first 11 crore, 12 crore has never been placed. And the second, my lord, the receiver over unsold areas, there are two problems. Number 1, those are anyway to be sold by receiver, for which he has yesterday filed an application for expeditious sale through receiver. Number 1. So it will not remain as my security. And number 2, out of that, I am anyway entitled to 40% of sale proceeds. So, my lord, and number 3, these unsold areas are not worth 12 crores. They'll be worth maybe 5-6 crores. All are in the first floor. So it's not a question of, my lord, double security. This is the entire case. That you have given me double security. You have given the claimant double security. I am saying you have given me no security. You gave me an order for security. The learned arbitrator gave me an order for security for 12 crores, but did not say that he would not be allowed to operate his bank accounts if he didn't give me this money. Net effect is he never gave me security, even though his challenge failed. So I failed over there to obtain an effective order of security. And number 2, the second form of security is, my lord, nebulous, because ultimately the flats will be sold and I'll get 40%. I'll request the learned receiver, the learned arbitrator, to give me his 60% also. But in any case, that is half. That's 5-6 crores. Now, point number 2. So, my lord, security is illusory, and this is what the learned arbitrator has considered while my lord rejecting his application. Second, this first order of security which he obtains, he challenges before the civil court, commercial court. Appeal is dismissed. Then, my lord, he comes and applies for modification before the learned arbitrator on the ground of appointment of receiver on the balance sale proceeds. And this is also rejected. So now he comes up in appeal. So according to me, there is no ground for him to again revisit this 12 crore security order, this initial 12 crore security order. Now he's challenging, essentially he wants variation of the initial 12 crore security order. You have never followed it. You have never given 1 rupee security. And your appeal has failed on merits. And the only ground for variation is subsequent appointment of receiver over the balance flats. Those are in any case to be sold. So there is no ground for variation. This is number 2. Number 3, this second appointment of receiver is because of your bad conduct, your 8 reckless acts of contempt. That is the punishment for learned arbitrator can't take cognizance of contempt. In the order, my lord, learned arbitrator has held these acts in contempt of court. When I move the application for enforcement, I'll pray for issuance of rule and committal to prison. But my lord, the second order of appointment of receiver is result of bad conduct. And it's not for security. Lastly, my lord, I have absolutely crystallized claims in terms of the agreement for about 12 crores. And I have claims, my lord, in damages for another 100 odd crores. Plus, he's prevented me from utilizing the second part of my land for the last 3 years. He's taken 6 months to file affidavits of evidence. He's taken 4-5 months to file written statement. He's changed his advocates thrice. This is his conduct. Now, my lord, please see, my lord, 2024 SCC Online, Delhi 6908. Paragraph 12, interim order, your lordship only interfere if it is perverse or manifestly arbitrary.
Para 12, right?
Para 12. Under 37. And this is, my lord, one step further. His 37 appeal has failed. He's applied for modification before the learned arbitrator. And now he's coming up from that and he wants, my lord, the original order to go. So he's asking your lordships to really review the order, dismissing the original appeal. This is what he's doing. My lord, it goes on to explain the law, but I don't want to, my lord, your lordship is well aware. I don't want to continue. Same, my lord. There is another judgment, my lord, of the Honorable Delhi High Court. This is 2024 HCC Online Delhi 7131. This is the first judgment. Paragraph 31 to 34 and 36. 7131. That from paragraph 31. It's not essentially on perversity. There are multiple factors set out in the impugned order. My learned friend wants a detailed without consideration of facts that ought not to be, my lord, permitted.
Correct.
Now, my lord, I want your lordship to Wonder versus Antox. Everybody is seen. You just show me the impugned order. My lord, my learned friend has given your lordship an impression. If interim award is not given,
Yes.
then on that admission, why should security be given? Please have a look at. My lord, please see page 622, volume 5. My lord, page 622. Also, my lord, something I forgot, my lord, to mention, which was very important. Of these 13 flats, which he has given a list to the arbitrator of 13 unsold flats. He's given a list to court in his applications. And I've annexed all that in the compilation. Now he tells the learned receiver that out of those 13 flats, in 3 flats I have already executed agreements for sale. No one's seen those agreements. There are multiple orders over the last 3 years asking him to hand over all agreements for sale. We've asked him 100 times. Court has directed him 50 times. Now he says, no, out of those 13, there are agreements for sale in respect of 3. Unregistered agreements. We all know what is happening. So even these, my lord, flats are nebulous. He's playing fast and loose with the court. My lord, please see, my lord, I am not on car parking spaces, my lord, and all that. Now, I'm certain your lordship would not be considering car parking spaces. It's on security. My lord, please come to page 623. My learned friend's arguments. My lord, he is on car parking space. And then, my lord, 627 is our arguments. And then, my lord, findings. List of 16th May order, my lord. Lordship has seen that, my lord.
That's what I'm saying. Page 625, his submissions are till
page 622, my lord.
627, you make submissions and then findings are 628.
Yes. So I am now going to show your lordship what is the subject matter that day. Because I distinctly remember most of the argument, what happened was, my lord, after car parking spaces, my lord, receiver took possession. They started saying, no, these are common parking spaces. These are as per the plan for common parking spaces. I have told RERA this is for him. All that he went with the receiver. All of it was rejected. My lord, and that is the crux of, my lord, that is not the crux, that is the whole and soul of his arguments, which resulted in, my lord, 16th May 25. My lord, see, my lord, his submissions at page 623. So this is, my lord, his submissions on car parking. And then, my lord, my submissions, and then page 628, findings. List of car parking, this is findings of the tribunal at page 628. And he wants interference on with this. List of car parking spaces sold to different purchasers as disclosed in page 88A of the reply does not tally with the list of car parking spaces disclosed by the respondent before RERA while submitting return.
For my learned friend's benefit, this part I have not challenged in my.
No, I'm showing your conduct, what your lordship is considering. So first contradiction, his list to arbitrator, list to RERA don't match. Notice was served upon the respondent by the receiver when the receiver took possession of the car parking spaces in terms of the order of the tribunal.
But for the conduct, Mr. Chaudhary, you had already filed a contempt petition, so that will be taken care of. As far as this proceedings are concerned, we will only see what is the legality, what is challenging, and what submissions you have to make.
No, the reason why I keep repeating, my lord, his conduct is bad and his contempt is, that is what has led to the passing of these orders. So the learned arbitrator is protecting the subject matter of the arbitration under section 17. Normally, your lordships do not put stringent, my lord, measures of protection like receiver. But while dealing with, my lord, a respondent whose conduct is like this, your lordship passes an order that both of us to go, my lord, and execute conveyance. I go and do it myself, and not once but 8 times. On the balance flats, your lordship will possibly be minded to put a receiver. This is why the receiver was appointed. And my lord, this is why the security is nebulous, because, and then he goes and says balance are already agreement for sale is there, possibly sitting at home he makes these documents. Now, my lord, please see findings of the tribunal. Notice was served upon the respondent by the receiver when the receiver took possession of the car parking spaces in terms of the order of the tribunal. Respondent did not turn up in terms of the said notice. Respondent did not cooperate with the receiver in identifying car parking spaces which remained unsold on the date when possession was taken by the receiver. Even the purchasers have not come forward complaining that possession of car parking spaces were wrongfully or forcibly taken, despite objection was raised. Even subsequently, no complaint was submitted by purchasers. Claimant also does not agree with the respondent as to the number of car parking spaces sold. Under the circumstances, it is not wise for the tribunal to direct the receiver to return possession of the car parking spaces to the purchasers as per list. This is one part of the order. So car parking spaces under possession of receiver remains. Now, my lord, please see the order, my lord, direction of the tribunal. Long and short of it, my lord, receiver has directed a meeting to be held and to find out what has been sold, and what is sold, released from his possession, if anything is sold. This is, my lord, part 1 of the order. My lord, I ask myself, Lordship has seen, my lord, page 630, and it ends at 630.
Yes.
So, my lord, meeting to be held, purchasers will come with, my lord, registered sale deeds showing sale. If it is taken possession of, will be released. Not a single car parking space will be released. Now, second part, supplementary development agreement. Here, my lord, the background is, in desperation because I was not getting Milord flats. I was not getting money. I agreed to take 6 flats. That is recorded in that document which I showed your lordship, that chart. I agreed. I agreed to the valuation also. Now, in terms of the agreement, he has to execute a supplementary deed, relinquishing his rights as developer, which, my lord, he did not do for 3 years. Despite order of learned arbitrator, he did not do. Ultimately, he receiver on his behalf executed. So this is the, now he says that there are problems over there. My lord, he was given the draft 50 times. He didn't say anything, he didn't do anything. All emails are on record. His earlier advocate on record approved the draft. This is part 2. Now please come to third part, which is at the bottom of page 632. My lord, here if your lordship comes to 632, please see findings, direction of tribunal.
Yes.
In view of submission made by such and such recorded above, it is directed by tribunal, value of 4 shops, 4 residential flats be appropriated. That order is already there. I'd agreed to that. We have agreed to the price. What is he saying? Then, my lord, see modification of order dated 26 February 2024, whereby he was directed to submit 11 crores. Now, please see his submission. Mr. Sen contended that when such direction for deposit of 11 crores and odd by the respondent was directed as security to secure financial interest of the claimant, receiver was not appointed over unsold car parking spaces. However, when the receiver has already been appointed by the tribunal and receiver has taken possession of car parking spaces, financial interest of the claimant has been secured by appointment of receiver. Lordship sees, he says receiver is the reason why the original order of security should go. Under changed circumstances, direction for deposit of 11 crores should be gone. I've given your lordship the facts on as regards this. Now please see the order.
Yes.
Which is at 641 at the bottom. The order for furnishing 641 last 3 lines, findings of the tribunal. The order for furnishing security was passed by the tribunal on 26 February 24. Respondent was directed to comply with the direction of the tribunal regarding furnishing of security within 1 month from the date of passing of the order. The order was not complied with by the respondent. Respondent challenged the order before the appellate forum, but ultimately became unsuccessful. Even thereafter, the respondent has not complied with the order. Now that the respondent is facing contempt proceeding. At this stage, they have taken out this application for modification of the order, as the claimant now can transfer 4 rooms and residential flats which were given to the claimant in lieu of its share towards its entitlement under the development agreement. My lord, may I just pause here? This is, my lord, those flats for which the supplementary agreement was executed. But the value was already deducted earlier. He now wants a double deduction. If you don't deduct the value, then I'm entitled to 16 crores. I can show that from the chart. My lord, his document, which is now discrediting, says 11 crores is pending after, my lord, deducting the value. And if you don't deduct the value, it will be 16 crores, 17 crores. A totally dishonest stand. It is true that the claimant can now sell shop rooms and residential flats. But since the terms of such sale have not been finalized at present, difficult to hold the actual sale price. In my value of units have been worked out to be 6.6 crores. It might be a hypothetical assessment. Sale price is more than 6.61. These 8 units are sold at a price. Then we can see the issue which has been raised. Admitted payment being equivalent, then still such and such is payable. This is where the learned arbitrator appreciates this argument. 642 bottom. Then still 1119 is payable.
Yes.
No, these are the facts. This is the order. Contempt will come up before your lordship any day, my lord. It's filed.
Anything else in the rejoinder?
Yes, my lord, I will. Your lordship permit me to come tomorrow, my lord?
You'll finish it? No?
I'll take some time to show, my lord. No, I'll finish, but I'll come with a short list of dates because my learned friend has hovered around facts. I will not go to the facts, my lord, and I will rely on the arbitrator's order only. I'll take half an hour and complete, my lord. Let us come back tomorrow. It will be easier, my lord. I'll come back with a short list of dates.
Tomorrow, কালকে fix করে দাও না।
Mr. Learned Senior Counsel, Vishnu Chaudhary.
আমি কালকে আসবো না।
Keep it for further hearing of the petitioner. Learned Senior Counsel, Mr. Shaukat Sen for the petitioner. The action is granted. Time to make further submission.
এটা কোথায় গেল? পেন্সিলটা
List on.
কালকে বিকেলে এখানেই করব।
Tomorrow.
ঠিক আছে। But tomorrow or day after.
The supplementary affidavit we have to prepare, no?
A lot of, your 34s are also pending.
Yes, but I wanted to
Finish your 34s.
I have only one, but it's not that.
Before I forget.
Because I'll have to affirm that supplementary affidavit also with that order.
Oh no, come back.
One day, my lord, I'll finish it. Because I want to come with that short note also and finish it up.
A day after tomorrow.
Whatever I said today, is all based on Millard documents which were in those compilations. But I chose not to Millard rely on those documents because it's at the
Well, I'll show that
interim
whatever he
application.
has said is also there in the documents which have been.
So I don't want to go Millard in that kind of detail. Otherwise, it will go on for 3 days. Millard, there's no point.
Great. এটা কি করব নেব না দেব
Which is the next matter?
কোর্ট নিয়ে নিয়েছে না কোর্ট দিয়েছে
হ্যাঁ
25.
ফেরত দেয়নি কোর্ট ভিতরে রেখেছে
25 কোর্ট নিয়েছে তাহলে আমার তো কপি ফেরত দিই
Lord, I appear for respondent, my lord. I am praying for.
Who's for the petitioner, madam?
She is not present.
Give me the file. What is it? What is the matter about?
But it's the application under section 37 of Arbitration Act, my lord. Kindly fix tomorrow the matter.
Not today. Take it down. None for the, wait, madam. Madam. None for the petitioner in the interest of justice. Adverse orders are deferred. Take her appearance, listed for tomorrow. Nobody comes and dismiss. None for the parties. In the interest of justice, adverse orders are deferred. Let this matter be listed tomorrow. Same lawyer.
Seven.
Same order.
Lordship, I'm appearing on behalf of the respondent in this
Respondent.
matter. Yes. Yes.
Petitioner, none for the petitioner.
I'm from respondent.
None for the petitioner. In the interest of justice, adverse orders are deferred. Respondent का appearance hearing list tomorrow. File दिखाना. Order schedule. None for the parties. The interest of justice, adverse orders are deferred. List tomorrow.
Nine. 29 is that matter, my lord. The lordship is not calling the non-commercial today.
The time. Oh. I'm sure nobody's here, so we'll call out the non-commercial.
Yes, they are not here, my lord. I'll be there tomorrow. We can do it, my lord.
Not today.
Not.
Non-commercial to check.
In item 30, I'm for the applicant, and I'm being led by senior advocate Jishnu sir, but I'm paying for not today, my lord.
Not today.
Much obliged.
Not 30.
Commercial matter.
Please do. My application. My petition
Lord, I'm
under
seeking
section
some
29A.
accommodation. My lord, if your lordship recalls, this is one of that matter where we relied upon a judgment, my lord, which is peculiar in the facts of that case, that perhaps may not by itself take us home. My lord, your lordship had given us time to file an affidavit. My lord, I'm just seeking 4 more days. My lord, the deponent, my lord, he's recovering from a...
Same thing they have did
He's-
before the learned arbitrator.
My lord, it's my claim. It's my claim. He can't be prejudiced. My lord, the person, my lord, has recovered
My
from a
counter
stroke.
claim also there.
My lord, we are also, my lord, drafts are ready. We are also preferring a 14 read with 15. So, my lord, both could be heard together. My lord, they're 29A and my lord are 14 and 15. Because we are not opposing, my lord, the extension because it's our claim. But, my lord, we, my lord, would pray for, my lord, an alternative arbitrator to be appointed. Kindly, my lord,
They
give
have
us 4 days
put
time.
Any applicant, the judgment, my lord, they have relied upon on the last occasion, my lord, this judgment passed while considering, my lord, section 29A6.
my lord, they have not taken out any application, my lord. This is my application for, my lord, extension of the mandate.
My lord, kindly allow us 4 days time, my lord. We'll complete, my lord, the affidavits. 4 days time I'm seeking, my lord.
Learned counsel for the respondent seeks and is granted further time of 1 week
Grateful, my lord.
to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 2 weeks. List on 24th February.
4 weeks, my lord, your lord.
24th February. 2 weeks, 2 weeks. 24th February. This month only.
Have you taken out any other application?
We will be.
1 week, 1 week.
1 week.
Great.
You want
No,
to?
no, he is referring to some other application he has
No,
filed.
we will be filing drafts at a
filing.
14, 15, both could be perhaps heard together.
What is the ground? Why do you want the arbitrator?
My lord, he's charging, my lord, money, my lord, beyond, my lord, the scope of the schedule of the act.
He has agreed to that, my
No,
lord.
my lord,
He has agreed
I
to
want
that.
to, my lord, I will show the
let them-
circumstances in which I agreed, my lord, to the initial fee, and my lord, how much business has been, my lord, transacted in this arbitration, at what pace, my lord, several, my lord, factors are there, my lord.
But once you have
Because this is the
Name
second.
arbitrator.
No, I didn't name anybody,
Yes.
my lord.
21, kindly go through your 21 notice. You have given the name. Propose this name.
The learned judge, my lord, in section 11 appointed, my lord, the arbitrator. My lord, I don't want.
Propose that
given
name.
the name of the arbitrator in your 21 notice, and the learned judge has appointed
Lord,
the same person.
my lord, I'm instructed it is not so, but even
I saw, my lord, this,
Lord, the
proposed
learned
that
chief
name.
justice, my lord, then the learned chief justice
He
appointed.
has only gone by your notice.
21
Section
notice.
21 notice.
My lord, but arbitration has been continuing, my lord, for nearly 2 years now. This is the second time, my lord, that my lord, a reason, my lord, has arisen, my lord, for extending the mandate. My lord,
File your reply, Mr.
yes, my lord. My lord.
Funny, if the arbitration is going on, you're paying money, everything is all right, then
And
finally
the verge
you
of completion, my
No, my lord, I will make out a case, my lord. My lord, once, my lord,
of the arbitration.
my lord, evidence is complete, now arguments are to happen.
Yes.
Finish it off.
Final arguments are to happen. My lord, even then, my lord, this will go on, and my lord,
why will it go on?
I will, my lord, I'm restrained in, my lord, openly, my lord. It's a retired judge ultimately. My lord, on affidavit, my lord, I'll make my case out. Every word I say may go against me also. My lord, now proceedings are, my lord, on online available.
Well, I'll show, my lord.
Yes.
My lord, for the first occasion, my lord, they linger this proceeding, my lord. I'll show, my lord, that, my lord, from the minutes of. Yes.
I will make out my case on affidavit, my lord. I'll only, my lord, refer to the relevant paragraphs and leave it to that.
All right, rest of the matters tomorrow.
Mr. Justice Pranab Chattopadhyay.